Yes, madam.
With visual losses, I beg to mention 37, my lord. Contempt case, of course. I need 2 weeks time to implement the
Response number one.
response number 1.
I agree for the response number one, Your Lordship. He has retired long time back, Your Lordship. They were supposed to implement the newly.
Newly incumbent.
Did you do your part to comply with the order? Is what we want
It's
to know.
regarding the compulsion appointment, Your Lordship.
Yes,
It will
my
be
lord.
depending on the DLC, Your Lordship.
Okay. Ms. K. Devi, Learned Counsel for the petitioner, has paid for an accommodation of 2 weeks to impede the respondents who are required to comply with the orders of the court. Mr. Edas, Learned Counsel, appears for the respondent number 1 and submits that the respondent number 1 has retired from his services. This the matter again on
In the month of July, my lord, after vacation.
15th of July.
Yes, my lord. Highly obliged.
Much obliged.
2026.
May I please your lordship?
Yes.
Lordship, with the consent of the other party, lordship, I beg to mention item number 27 of today's list, lordship. Lordship, in this case, Mr. Somo is out of station, lordship. So can it be taken up after, before lordship, 5th of June, lordship?
An adjournment slip had been circulated by the petitioner with the consent of the counsel for the respondent. Stop. Accordingly, list this matter again on the 5th of June or agot kibara date. 3rd? 3rd of June.
May I please your lordship?
Yes.
Also, with regard to item number 28, lordship, we
28.
circulated the
Ah.
adjournment request, lordship.
Oh, yes.
I'm praying for accommodation for today, but however, lordship, if it is not inconvenient to the court, can it be in the first week of June, your lordship? Because there's because the division bench is waiting because of the single bench order, lordship. Lordship, on 4th or 5th, your lordship. Or maybe on 9th.
9th is possible.
9th is possible, lordship. Much obliged, lordship.
9th. A baki kini eke thakibwe adjournment slip
Yes.
circulated on behalf of the learned senior counsel. Huh?
Much obliged.
Lordship, beg to mention item number 8.
8. Yes.
Respondent has already filed their affidavit.
Ah.
We need 2 weeks time to file the rejoinder.
The counsel appearing for the petitioner has sought for an accommodation to file reply to the affidavit in opposition filed by the respondents. Full stop. For meeting the same, list the matter again on when?
The 2 weeks needed.
7th of June. Huh? 7 is a Sunday. 2nd of June. Yes.
May I please, your lordship? Lordship, I beg to mention item number 60.
1660.
60. It may be adjourned for the day, lordship.
The request of the learned counsel preparing for the applicant. List this matter again on when?
Lordship, after 3 weeks, lordship.
June or last summer. 24th of
Lordship,
June.
date may not be fixed. We are yet to receive some instruction from the
24th of June, sir. We cannot do, but we have to fix the date. Ah, Matok. Yes. Yes, madam.
Instruction as per the last honorable court's order, lordship.
Monthly family pension. Yes, sir. Yes, who's for the respondent, sir?
Extraction. M. Bhattacharjee, the government.
Yes, Lordship. Lordship, kindly pass over the matter at this time.
After something, no? Yes, sir.
What's my pleased to see order dated 7/3/2026, particularly paragraph 6. Lords.
Yes.
So therefore, on
Lots.
4/4/2026, same thing is repeated. This court has taken matter very seriously about some lenient views taken again. Except they promise to pay the amount to the petitioner within this period. Lordship, till date, not a single paisa has been paid.
Yes,
Lordship, as per our instruction dated Lordship, 3326 Lordship, the fund due to non-availability
now,
of fund.
how many vehicles are available and what are the tables and chairs available in your office? Kindly give us a list by 2 o'clock.
Yes, Lord.
We'll
We'll
ask
obtain
for
an
an
instruction,
auction of the
Lordship,
office. We'll ask for an auction of the office.
by tomorrow, Lordship, by
We
tomorrow.
will ask for an auction of the office, the vehicle of the chairman, the engineers, the whoever are there in the office. Everything will be auctioned off.
So by tomorrow, we will obtain instruction,
Huh?
Lordship. By tomorrow, Lordship, I will obtain an instruction,
They are
Lordship.
drawing their
By
petrol
tomorrow,
dues.
Lordship. By tomorrow,
They
Lordship.
are drawing their extra emoluments
Lordship, I will
above, apart and
trying-
above from the
I'm
salary.
trying to obtain instruction, Lordship.
No.
I'm trying to, Lordship.
What, tomorrow first item?
As a first item, Lordship.
Tomorrow the first item.
Lordship.
Heard Mr. S.C.K. Leonard, Senior Counsel, appearing with the assistance of R. Hussain for the petitioner. This court has noticed several times that paucity of fund for payment of the arrears of the petitioner cannot be a reason to deny payment of admitted amount. The order dated 7/3/2026 had recorded that the court has restrained itself from passing further orders. However, keeping in view the unfortunate state of affairs, it shall be left with no option but to issue a writ of mandamus, directing payment of admitted dues to the petitioner with interest, and such interest to be recovered from the salary of officials whose fault such payment has not been made, including all the members of the board.
Lordship, I am appearing for respondent number 3, Lordship.
Who is three?
3, Lordship. State of Assam represent Commissioner and Secretary, Urban Development
Are
Department.
you related to the board in any manner?
No.
Yes, Lordship. Lordship, make list.
You are someone in the
Lordship.
board?
Lordship. Lordship. Our duty.
From him also.
Lordship. Our by tomorrow, Lordship.
The
By tomorrow.
the learned counsel appearing for the respondent number 3 has sought for an accommodation till tomorrow to have his updated instructions. List again as the first item, list again tomorrow. Matter will be taken up as the first item.
Obliged, Lordship.
Lordship.
It's already settled, madam, by the mediation center, madam. Executioner has also, madam, got reliefs, madam.
Hmm?
P11, madam.
Heard Mr. So-and-so and counsel appearing, Mr. K.R. Patil and counsel appearing for the petitioner. You are appearing for?
I'm for the, as a legal aid counsel for respondent number 7.
Mr. So-and-so who has legal aid counsel for respondent number 7. Mr. Chakraborty, you are appearing?
Respondent number 4.
Mr. Chakraborty appears for the respondent number 4. Your name, sir? P. Hazarika for 1, 3, and 4. 1, 3, and 5. Full stop. The matter was referred to mediation by the order dated 12/8/2025, and the learned mediator has informed this court through the report dated 3/11/2025 that the parties have reached an amiable settlement during the mediation process. The relevant portion of the mediation report is reproduced herein below for ease of reference. Full stop. The learned counsel for the parties have submitted that the parties have indeed reached the settlement as recorded in the report, and nothing remains in this writ petition to be adjudicated further. Accordingly, this writ petition is closed, directing both the parties to do their necessary bit in accordance with the settlement arrived at before the mediation on 3/11/2025.
Much, sir.
On 3/11/2025, as recorded in the report dated 3/11/2025, writ petition disposed of
Much, sir.
on settlement. Yes, sir.
Lordship's childcare leave she paid for Lordship with effect from 2020.
Huh?
She paid for childcare leave, extension of her childcare leave for another 18 months in the year 2020, Lord.
Hmm.
But Lordship,
Has
there-
she joined her services
Lordship,
thereafter?
nothing, Lordship, no instruction, Lordship. It has come for the second time, Lordship. after.
Maybe.
So, Lord,
He is asking for her arrear salary and
area salary, Lordship.
the extension of the childcare
Care
leave.
leave.
Is it
Yes,
not?
Lordship.
The leave has already been taken, availed.
No, Lordship, that instruction I did not have, because during that time, Lordship, COVID, there was a notification that there will be no childcare leave. There is a notification, Lordship,
Saying that there will be no.
childcare leave during that COVID period, Lordship.
So if the child suffers during
No,
the
no,
time,
Lordship,
the
she
mother
was
thinks
already-
that I should go.
No, Lordship,
attend my
extension. She is asking for an extension. Initially, she was granted, Lordship, 32.
So from when to when?
From
Samaguri,
18
she turned
months,
in
Lordship,
August
for one-
2020. Just a minute.
for further periods of 18 months, Lordship. 32.
7/9/2020. None appears for the petitioner on call. Mr. Srinsul and counsel appearing for the health department
Yes, Lordship.
has prayed for an accommodation to have his instructions in the matter. The writ petition was filed in the year 2022. Notices was issued on 1/4/2022, and thereafter the matter was listed once on 24/4/2024. The matter has been listed thereafter today only. Instead of accommodating the learned counsel for the respondent to have his instructions in the matter, place this matter again on. Junot diok bondho age age. 24th of June, 2026.
Highly obliged, Lordship.
Lordship, humble apologies for interrupting. Colleague had mentioned one item number 60, Your Lordship. It's actually a fresh matter, Your Lordship, but the date given was 24th June.
Ah.
Could it be accommodated in the first week of June? Your
I
Lordship?
think it was, they prayed for 3 weeks. 3 or 4 weeks was the prayer.
He had inadvertently made that mistake, Your Lordship.
Yeah, that's right. 10th of June.
10th of June. Could it be in the first week, Your Lordship? 5th.
We are accommodating you in the middle of a running list.
I
Be
apologize.
thankful
Your
for
Lordship.
that. We'll
apologize.
bring it up on 10th or make a mention before that. Yes, sir.
Pass over for timing, Lordship.
Why?
My senior is under court on another matter.
Huh?
My senior is court number.
Show us something where we can say that yes, if the senior is in another court, we should pass over. What is the matter about?
The matter about is casual employee as a tax collector officer in petitioner number 1 and 2, Lordship.
They are casual employees.
Yes.
What do they want?
My senior learned counsel appear in this case, please pass
Hmm?
on, Lordship.
I mean, be prepared with the facts of the case. Yes, Mr. Kolika, tell us.
Yes, regarding Lordship, only that this petitioner, about this petitioner, they applied for compassion appointment. However, Lordship, they were appointed Lordship on works as a works employee, which is Lordship against the rules of compassion appointment. So now Lordship, thereafter Lordship, they have approved the concerned authorities to upgrade their service to from workers to Lordship regular employees. And government has also communicated to the department also, and department has also informed the government that still there is 2 existing vacancies there, so they may be upgraded the set 2 posts. Now, Lordship, they have passed a order whereby our player has been rejected, Lordship, citing a wrong Lordship notification that at page 40.
1440.
40, Lordship.
40.
Lordship. Thus, I am reading the relevant portion. Sir, with reference to the subject cited above, I am directed to state that your proposal for upgradation to regular post in respect of Srimati Binita Kolita, works as Khalasi, and Srimati Karabi Methi, works as Khalasi on compensation ground is hereby rejected as per provision laid down in Finance Department.
Okay.
This is not relevant at all, Lordship, in this case. So now they have filed their written affidavit in opposition also, Lordship. In the affidavit in opposition, they themselves has Lordship stated that alia application was wrongly rejected, so it should be reconsidered, Lordship. They have stated in their own affidavit itself. Page 64 of their affidavit in opposition.
Page 60.
4. Lordship will see the last 3rd line of 1st paragraph of page 64. Starting from the right hand side, Lordship.
Yes,
And
Mr. Chaudhary,
Lordship.
kindly tell us how early is early? Huh? The last line in page 64 says reconsideration at an early date. That was in the year 2023.
Exactly, Lordship.
So how early is
No,
it? Kindly tell us.
difficulty is
Huh?
there, Lordship. It is lying with the government and the
Represents the government.
well, and friend is representing the
Page
government.
number 40 was issued by whom?
Lordship, by page 40 was issued by the Lordship under Secretary.
You are appearing for the
Joint
Department
Secretary.
of Housing and Urban Affairs, sir?
By respond number 1 and 2, find the affidavit in opposition.
Tell us. How do you support that? And show us the scheme for compassionate appointment which allows on ad hoc basis,
On works as Lordship.
on work charge basis. When you say work charge, people are not within the government. How do you appoint persons to work charge basis? Although Mr. Chaudhary is sitting with you, he is against you.
Lordship.
You are alone in this fight.
Lordship. Lordship, in para 14, Lordship, may I read, Lordship? Of our affidavit in opposition, Lordship, which is filed by the respondent 1 and 2, Lordship.
2.
14,
What do you say?
59, running page, Lordship. May I read, Lordship? That with regard to the statement made in paragraph 13, 14, and 15 of the writ petition, the deponent begged to state it is fact that the board had informed the Joint Secretary to the Government of Assam, Department of Housing and Urban Affairs Department by the letter dated so and so, that the two number of vacant posts of regular Khalasi under the board. It was also stated that no fill up the post
Who
of
appears for
government
the
approval.
Finance Department?
Finance. Finance.
Yes, standing counsel finance at us told you. Are you there? After some time, let the finance come. Not.
Lordship, with regard to item number 2, Lordship, some instruction is
We don't have item number 2 with us.
Lordship has fixed it tomorrow, Lordship.
Tomorrow, yes.
Lordship.
We have, huh?
some instruction received, and accordingly, the same thing, it has been sent to the government for approval. It is not received from the government. We are ready
So
to.
either you arrange for the approval by tomorrow morning, or you give us a list of all the vehicles and tables and chairs and almirahs that you have. The main payment will be from that, and the interest will be from your salary, from the members of the board, as per the last order. And you can recover from the government, take your own sweet time, no difficulty. Take your own sweet time. Tomorrow morning,
Then on Monday, Lordship.
tomorrow.
Because from government is very difficult, because we have the instruction that I have received,
Tell
Lordship.
tomorrow morning what efforts have been made.
Exactly,
within
Lordship.
today.
Exactly, Lordship.
What has happened within
Then
today.
day
tell
after
us.
tomorrow, Lordship. Because I will communicate to them.
We
today
have
on-
given it on the presence of the petitioner. If required, we'll again relist it day after tomorrow. Don't worry. We are not that hard. Item 9.
May I please, Lordship? Lordship, the
Anything on settlement?
Response number 5, Lordship, filed
Could
and
not be reached, my lord. Settlement could not be reached, my lord.
Huh?
Mediation
Settlement
failed,
was
my lord.
failed, Lordship.
Why?
Because there are some disputes regarding amount of money to be given, my lord.
Respondent does not want to proceed with the mediation. Why? Okay, anyway, what is the case?
Lordship, the petitioner is a mentally retarded person, Lordship. 73% of physically disabled person, Lordship. And Lordship, after death of his father, Lordship, his stepmother, Lordship, received all the gratuity and all the pensionary benefits, Lordship. And now he is getting, Lordship, pension, Lordship. So I am totally deprived, Lordship. Now, not a single file, Lordship, I have received, Lordship. This is the case, Lordship. And Lordship, earlier, Lordship, the petitioner's brother filed case, Lordship, and due to non-mentally petition, Lordship, it was dismissed, Lordship, because he himself filed, Lordship, without making the petitioner as party, Lordship.
Oh,
And Lordship, thereafter, Lordship,
yes, according to which rule? You get your
Lordship, about Lordship, 32 lakhs, Lordship, she received, Lordship, but Lordship, no, about 32 lakhs, Lordship, she received, Lordship. And Lordship, here, Lordship,
there is a saying in English, to each his own. Everybody will get only what is written here. 32 lakhs gone. Tell us what, under which law, under what provision of law we can consider
at
your.
page, Lordship, 25, Lordship, kindly see the Lordship notification, I have annexed, Lordship, but sub 1, Lordship. At page 25, Lordship.
Page 25.
Yes, Lordship.
A pension rules can be questioned.
Of the petition, Lordship.
Ah.
Yeah, Lordship. Insertion of new rule 143C, Lordship.
Yeah, that's not one idea. Right. Department of Sullivan. Not being paid to piano. And it meant good. Yeah, it will be some piano. It exists on the pension and finance has not been paid. Ah, it is.
Tell us the rule. You are entitled to a family pension.
Lordship,
That we agree to.
Lordship. 143C, Lordship, 1. This rule shall apply to pay a lifetime family pension to the handicapped sons, daughters of government servants retired died while in service, Lordship. If the son or daughter government servant is suffering from any disorder or disability of mind,
It shall be payable.
Lordship,
The question is when another person is already drawing it.
Lordship.
Someone is drawing it. How do they give you either two pension orders or like the compassionate family scheme? Is there any provision where the government can divide the pension?
Lordship,
Was that it can be divided between two persons? We will ask the government to do it.
Lordship, where, Lordship?
Your earlier repetition from
Yeah.
what we have read in that order, there was some allegation of fraud, forgery.
Yes, Lordship.
What happened to that?
Lordship, the case was filed, Lordship, before the appropriate forum, Lordship.
Then what happened?
Petitioner side, from the petitioner side, Lordship.
Then what happened?
This is pending, Lordship, now, Lordship.
Where?
Lordship, Borpeta police station, before the court, Lordship. And he made also representation before the authority also, Lordship. The petitioners.
Yes, sir, you are appealing for?
Response number 5, my lord.
You are the mother.
Yes, my lord.
Lordship, our Honorable High Court also, Lordship, earlier version, Lordship, some passed some orders, Lordship, regarding
Plus,
Lordship.
are you disputing the status, the mental status, the disability status of the child?
He has some disability, my lord. That I agree, my lord.
And you were ready to part with some money and he did not accept the amount, or he had demanded an amount?
He
and
had
you
demanded,
part-
my lord, he had demanded that
What is the amount that you would like to part with?
during settlement matter, we are ready to pay up to 4 lakhs, my lord.
Out of the 30.
32, well, because one thing is there, my lord.
Just a minute. Out of the
Right.
32 lakhs, you are agreeable to pay 4 lakhs.
Yes, my lord.
And what about the family pension, which should be?
Not given, my lord, as yet.
It has not been
No.
released.
GPF not paid, my lord.
And what amount have you already received?
Around 32 lakhs, my lord, almost.
Already received.
Received, my lord.
And the GPF is yet to be received.
Yes, my lord.
Is 32 lakhs was what?
But
the earned leave,
earned leave and leave
Gratuity.
encashment and all these things, my lord.
gratuity, leave encashment and all.
Group insurance and all these things, my lord.
What is your age, sir?
Now lordship, she is lordship.
And what is, she or he?
He lordship is sorry.
He, and what is the disability percentage?
AG lordship at page. In the year 1994, he was born lordship. Now 32 years lordship.
2 years. Now, one of your certificates shows that you are mentally retarded. What is this?
Lordship,
Page 17? And why does the opinion differ at page 19? Hmm?
he has no sense of duty lordship from his birth lordship.
He has no sense?
Sense of duty lordship.
Duty.
Yes, lordship. Like a lordship, met tech.
That is not what the disability certificate says. At page 19, it says that you are blind. Are you blind or are you?
Not blind lordship.
You are giving me a certificate saying you are blind. Oh,
Mental retardation, lordship.
My mistake, my mistake.
In the last bottom side lordship.
My mistake, my error. MR mentally retarded 73%. Yes, sir. When did you marry the person? When did you marry him?
97, man.
And he was born in 94.
Well, as per the affidavit of the department, my lord, the amount paid is only 11 lakh something, my lord.
What from where did you get the rest of the money? You say 32 lakhs.
33, exactly, I am not sure, my lord. Because from their record, the record it says, my lord.
Who is appearing for the department?
Home department, my lord.
You are not showing us the law.
Yes, lordship.
Mr. Borua, you appear for the AG. What does your this thing say about the distribution of the DCRG? Seriously, payment for this.
My lord, first and foremost thing, DCRG is to be paid among the, but here all documents sent to us in favor of the son of 5. Nothing is being mentioned about this. It is whatever amounts are coming up, we'll be paying to that, to whom we are paying. No, we cannot say this. Honorable Court will say, to whom we are issuing PPO.
No, you will issue the PPO to the wife. We are not concerned with that. We will make the arrangement if necessary, if we find necessary. What we are trying to understand is, he is entitled to a certain portion.
Yes.
Of the pension. Pension rules do not say how the rest of the DCRG is to be distributed. It talks of pension, family pension. It does not talk of the DCRG, the death cum retirement gratuity and all that, or the leave encashment, or whatever else was there when the person died. That was his own earning. Now, if they want a division on that, it has to be a different kind of a litigation than a writ petition. What we are,
Your lordship,
so far as the pension is concerned, it is done as per the rules.
as per rules. Now, DCRG also is being paid, same principle. But whether their names are there or not, we have to verify these all documents, because these all documents sent in favor of all respondent number 5.
And no one is appearing for the Home Department today. Okay, we'll have some post, huh?
Home Department, I am appearing.
Yes, tell us.
Yesterday, she has filed one reply. Who? Sorry. Achha, you have filed. That's it. That is not on record.
Tell us. How do you propose to do it?
Lordship,
There is a man who is mentally imbalanced.
Lordship. He may get, Lordship. He may get.
He will get.
Yes, Lordship.
He will get. Now, how do you propose to do it?
Yes, propose. Lordship, I think the Treasury officer can take the arrangement, Lordship.
To do what? There will be one pension payment
Yes,
order.
yes, Lordship.
And we can direct the Treasury officer to proportion the two amounts and give it to each of them.
It may be, Lordship.
Has it been done prior to this?
Prior to this, Lordship, I have to take, Lordship, the Treasury officer, the Standing Council Finance are appearing, Lordship. They have some experience regarding such cases, Lordship.
135, huh?
The afternoon, money ultimately to Treasury officer, heady curious. No, কিন্তু ultimately divide to নহব, কিন্তু তেওঁলোকে divide কৰিব পাৰিব within their কিন্তু গভৰ্ণমেণ্টে ৰেলৱেত যে কৰি দিওঁ কেনেকৈ ক'লে ৰেলৱেত যে কৰিছোঁ
Yes, the DCRG has it been disbursed?
Yes.
What has been disbursed?
As per affidavit of the department, my lord, it says, my lord, in paragraph 6, my lord, page 47, my lord.
Just a minute.
Their affidavit, my lord.
Just a minute. Do you have the pension rules, sir?
Yes, ma'am.
Have 136?
143 or 36?
136.
136, ma'am.
Yes.
Yes, ma'am.
The
Nomination
family is described. Is it? Who is family?
Family for the purposes of this rule will include the following relatives, my lord. Wife in the case of a male officer, husband in the case of a female officer, sons, unmarried and widowed daughters, brothers below the age of 18 years, unmarried or widowed sisters, father, mother.
So these are the persons who would be entitled to it?
It includes in the family, my lord.
So either whether he's a
he's a member of the family, my lord.
Whether he's a disabled person or not, being a son, he's entitled as family.
Family, my family.
Now have 135.
Yes, my lord. Date come retirement gratuity.
Date come retirement gratuity.
Man.
Please see 2.1. Sub-rule 2. Further sub-rule 1.
2.1. If there are one or more surviving members of the family, as in items 1, 2, 3, 4, of sub-rule 1 of the Rule 136, it may be paid to all such members other than any such member who is a widowed daughter in equal shares. Yes, my lord. But 143(3) says, my lord.
That is pension. You have received the DCRG
My lord.
and it was required to be paid in equal shares to everybody except a widowed daughter. Is it? Is it?
Sons, my lord.
The both the sons were entitled to part of the DCRG?
Yes, 4 sons, my lord.
Then there will be 4 shares and your share is 5th share. You have taken the whole of it.
Yes, paid to me, my lord.
Keep 1/5 to give the others. We cannot go beyond the law. We will have it recovered to the department.
But can it be on any other day, my lord? Today I'm not prepared, my lord.
Eh?
Any other day, my lord.
He is not getting a single paisa, sir. A mentally disabled person is before us.
No, he will get on Friday, my lord.
Person with disability is before us. Matter has come up from when? 2022.
22.
Person died when?
Often died on lordship
6, 2016 over there.
16.
2016, I think.
died
Entire
19 to
money will be
2018
recovered
lordship.
from you.
18, man.
18.
Entire money can be recovered from you, like land revenue. I don't know how they do it. Baki jai. Huh?
So only
Either-
DCRG amount,
either-
my lord. You're also
either-
talking about DCRG amount.
That is what
DCRG
comes.
amount has been paid by 7 lakhs only, 7 lakhs,
So divide it into 5, keep one part.
my lord.
Divided it into 5, keep one part.
But there will be another son is also 5 sons there, my lord.
So if we,
I have one son also, my lord.
if we keep on going, what happens to the leave encashment?
My lord.
All, your 4 lakhs,
Total six family members are there.
your 4 lakhs offer may not be. Huh?
It is 7 lakhs, my lord. So it
Your
almost,
4
it
lakhs,
was,
your 4 lakhs offer.
yes, my lord. It was
Along
almost,
with
almost.
the leave encashment and other part of the 32 lakhs, we do not know what other law we will find out. Scraping through the book. Now, once
Provision
we start
DCRG.
scraping, another round of mediation,
My lord.
huh? Some reasonableness, some reasonableness. If it is 32,
I know, I'm not sure.
Other-
I'll not.
other
I'll
5
my
are
lord.
not, other 4 brothers are not asking for it.
You also will go as per record, but I am not saying 32, man.
I'm just saying,
Yes, man.
whatever be the total amount.
Yes, yes, yes.
The rest of the 4 brothers are not
Before
agree
asking.
with you with whatever has happened. One person who cannot fend for himself
Man.
is asking for respite,
No, I am ready to pay for him, my lord.
so that everything which was there, you are entitled only to 1/6 of the total amount.
2/6.
Why
My son is there.
Huh?
My son is also there, my lord.
It will be for him. That
Yes, yes, okay, man.
1/3 for
1/6, 1/6, man.
anyway, 1/3 you can keep. Let us say 1/3.
Man.
The rest of the 2/3, even if he is not entitled to the whole of the 2/3 because of the other brothers, and they don't demand anything. Out of
But they
2/3,
demand, my lord. In that mediation, they came, my lord.
no,
No, on behalf of him, lordship, they came.
they are not praying it for you.
No, they have not come. During mediation, they came, my lord.
For what? For him.
Seeking share, my lord.
For him.
Not for him, my lord.
Is that so?
Yes, my lord.
No, lordship, actually, though they are entitled, lordship.
Your lordship will say if they do not want, he will get. Then your lordship will see what happens, my lord.
We will not allow the others to participate in the mediation center before the mediator. They will not
For amicable settlement, they were called, my lord. Because we know that they are also asking for money. Well, in fact, although they did not come before the court.
We are interested in his share.
No, yes, that is of course, my lord. I am ready to pay for him, my lord.
On Friday.
My lord.
We'll take it up on Friday.
On Friday, my lord, my lord.
Kindly have your instructions from
My affidavit has been filed. Today it is filed.
from your client.
Yes,
your
ma.
instructions.
Actual amount, well, I will take.
In view of this,
My lord, my lord.
is it a recovery or is it a settlement?
My lord.
And you also find out what is the actual amount that has been received, because otherwise, yes, department, you are for the department.
Yes.
You have given the DCRG.
Yes.
Have you seen section 135? Rule 135 of the pension rules.
That's the problem.
If it does not come out from the respondent, we will take it out from the salary of the persons involved.
Yes, Lord.
All that lakhs of rupees.
No, Lordship, before filing this petition, Lordship, we have no knowledge about his disability, Lordship.
Not necessary. Disability is gone. Divorce the disability. Please have Rule 136.
136, Lordship. Family of the proposer.
Who are the family?
Yes. Wife,
Wife.
in case of the male officer.
Sons.
Husband, in case of sons, unmarried daughter, brother.
Okay. We'll
above
stop at
18
that. We'll
years,
stop.
father.
We'll stop
mother.
at that.
Yes, Lordship.
Wife, son, unmarried.
Yes.
Now come 2 pages before at 135.
134, Lordship.
Sub-rule 2.
Sub-rule 2. If
And thereafter sub-rule 1.
If an officer
Who has completed
5 years qualifying service dies while in service, a gratuity not exceeding the amount of specified in sub-rule 3 may be paid to the person or persons on whom the right of receipt of the gratuity in confirmed under rules 136, or if there is any such person. So 136, those persons.
Please go ahead.
Yes.
Sub-rule 1.
Yes, sub-rule 1. If sub-rule 1, an officer who has, yes.
2 sub-rule 1.
2 sub-rule, yes, Roman 1, yes. If there are one or more surviving members of the family, as in item 1, 2, 3, and 4 of the sub-rule 1 of the rule 136, it may be paid to all such members other than any such members who is a widowed daughter in equal shares.
Now we wait here for a moment. You had the family history.
Yes.
You know there is a wife.
Yes.
There are 4 sons.
Yes.
Or 5 sons.
5 sons.
5 sons.
Yes.
6 persons waiting. You paid to 1.
Yes.
Fine.
Lordship, the benefit accounts. Lordship,
you held the money.
Yes, Lordship.
You were supposed to give it in accordance with the rules.
Yes.
You had the family members known.
Yes.
And you give it to 1.
No, what is the general rules? What is
so kindly have those documents which were forwarded.
Because Lordship, they I think the no objection yes.
Kindly have the records.
Yes, Lordship.
A 73% disabled person, can he give a no objection?
Yes, that is the.
He could not have.
Lordship, maybe I have to take the instruction.
We'll have it on Friday.
Friday, Lordship.
On Friday.
Next.
We
Friday.
don't want much matter.
Lordship,
much detail on this.
This Friday, Lordship, this week. Today is Wednesday, Lordship.
We want just to, because it is from 2022.
Lordship.
We just want to know.
I will try, Lordship.
When you released the money. When you released the money.
Can it be on Monday, Lordship? Because we have only 2 working days here.
When you release the money, the DCRG.
Yes.
There must be a proposal, a sanction, or something.
Yes. So before sanction or proposal, I think some caution should be necessary, Lordship, from other successor, Lordship.
There will be one file which will deal with all this.
Maybe.
It is money.
Yes, maybe.
Get us that file.
Lordship. I
heard Mr. Swensulan Council paying for the petitioner.
It will do. affidavit আমি এইটো কৰিম।
It also heard গোটেইকেইজনৰ নাম দি দিব হা কোন কাৰ কাৰণে আছে। By the earlier order of 28/8/2025, this court had referred the matter to mediation. However, by the report dated 23/10/2025, the learned mediator has submitted that the mediation has failed. Full stop. The matter was today taken up for consideration, and after some arguments,
district board
the learned counsel appearing for the Department of
Lordship, I am appearing on 1 and 3, Lordship. It is the
just a minute for
Home Department, Lordship.
the Home Department.
And
For the Home Department.
yes,
for
Lordship,
the
yes,
Home
Lordship,
Department, comma, who also represents the respondent number 3.
Oh, 1 and
Yes.
3, Lordship, yes,
1 and 3
yes.
has submitted that a perusal of the documents of the a perusal of the records which led to the release of the DCRG to the respondent number 5, despite the existence of other family members and other family members would be necessary for a proper adjudication in the matter. Full stop. Rule 135 of the Assam Service Pension Rules 1969 provides that the DCRG is required to be paid to the eligible family members in equal shares. Full stop. The prayers in the writ petition are for release of family pension in favor of the petitioner, comma, who claims to be a person with benchmark disabilities and the son of the deceased government servant, comma, along with the DCRG of the deceased. Full stop. Any stay operating the matter restraining you from disbursing?
No.
It has not been disbursed to you, that 4,92,000, has it been disbursed to you?
Two amounts have been discussed. Three amounts, well, till now.
Where do you find that amount?
Yes, Lordship, in my affidavit,
Affidavit,
Lordship,
What
it
are
is
the amount?
categorically stated that the amount of DCRG amounting rupees 7,78,536.
Where do you find it?
Yes, it is page 49, Lordship. Continuation of para 7 in the from the earlier page, Lordship. Para 7 in my affidavit, Lordship.
The affidavit in opposition filed on behalf of the respondent number 1.
Yes, Lordship.
Reflects that leave salary amounting to rupees 4,30,549, comma, provisional DCRG amounting to rupees 7,78,536, comma, GIS saving amount of rupees 66,812, comma, and GIS amounting to rupees 2 lakhs have been paid to the respondent number 5 in the matter. Full stop. The order does not, the affidavit does not reflect if there is any other amount. Pending with the government to be paid to the legal heirs of the deceased government servant. Full stop. List this matter again on. When can you get it, sir?
Lordship.
When can you get?
Monday, Lordship.
Monday. Monday did you? Huh? On so and so date? Monday would be 25th. On 25th of May 2026, on which day the learned counsel representing the respondent number 1 and 3 shall produce before
Lordship.
this
1 and 3, Lordship.
1 and 3 shall produce before this court the records on the basis of which the DCRG amount had been released. DCRG and other amounts had been released to the respondent number 5, despite the provisions of Rule 135(2) within bracket Roman 1 of the Assam Services Pension Rules 1969. Full stop. The learned counsel for the respondent number 5 shall also be at liberty to inform this court if the respondent number 5 is willing to undergo another round of mediation with the petitioner in the matter. Full stop. In the meantime, it is provided that if any further amount is pending to be paid to the legal heirs of the deceased government employee, no such payment shall be made solely in favor of the respondent number 5 without leave of this court.
It is good. Lordship.
If you want to release any more amount,
No, Lordship.
giving shares to everybody, please do.
Lordship.
But if you want to release it to respondent number 5, tell us and
No,
do it.
okay. It is word, Lordship. That's
Mr. Bower, attendance to the city.
Well,
Yes, sir.
19. 91.
5. Yes, sir.
My lord, in this case, Lordship, petitioner before your Lordship, they are the tax collector, Lordship, for praying for upgradation of the scale, Lordship. Some juniors were given, but they were deprived. However, their name was referred to the commissioner for consideration of their grievances, Lordship. And they filed a representation also before the page 30, Lordship, annexure 4, for which was also pending till date. And just last night, I asked the petitioner's Lordship, their case again referred to the government for upgraded scale, Lordship. So if necessary, Lordship, I will file additional affidavit or to refer the matter to the commissioner to consider our grievance, Lordship, since other juniors are already considered.
To pass a speaking order on the same.
Lordship.
If we direct the commissioner to pass a speaking on the order on the same, the petitioner should be satisfied for the moment.
Lordship.
Is it?
That Lordship, their name is already referred.
Huh.
Last night I came to know, Lordship, from phone call, Lordship, from the.
No, what is your prayer today, sir?
Prayer to get the upgraded scale, Lordship.
What do you want the court to do today? Hear the matter? Is it ready for hearing?
It will take time, Lordship, so let the matter may be referred to the commissioner, Lordship, so that they may get benefit of
On a
that,
disposal.
Lordship. I pray, Lordship, the other side, the
Wait,
government
yes.
penalty is not again.
PNRD.
Lordship.
Finance is also a party.
Lordship.
Mr. Borpujari. Finance is a party in this matter. They claim to be, you are what?
The tax collector for upgrading the scale.
They are tax collectors who are casual employee tax collector.
Lordship.
Casual employee tax collector. Persons who had joined after them as casual employee tax collectors or other posts have been
Lordship.
allowed an upgraded pay scale.
Upgraded
Pay scale. They have made their representation, no answer, and he has instructions from his client that the matter has been again referred to the Commissioner Secretary of the department
Lordship.
for consideration of the upgradation of the scale.
Commissioner and Secretary of the department.
Concerned department.
Yes, PNR, the employer.
So he is saying that the matter can be disposed of, giving a time frame to take a decision. And only if it is rejected would they have a case for a writ petition to challenge that particular order.
Yes.
As of now, the views of the finance, views of this matter will keep lingering. It has been kept lingering from 2022.
That can be
If we
done
fix a time frame
because
and direct the commissioner to take a call on the representation
call on the
Along with
representative.
all-
within a time frame.
Because then the authorities will be bound to, my lord, disclose the results. And thereafter, a fresh cause of action will accrue in his paper, if at all, my lord, rejected.
We are against disposing writ petitions saying that passes speaking order. Therefore, we are having an interaction.
Timeline because of pendency of this kind of matters, my lord.
Because the department will not take a decision, there is no affidavit as on date.
Because once your lordship disposes of this application, writ petition, the authorities are bound to take a call, otherwise non-compliance.
So we'll dispose it of because
Yes.
none is there for the PNRD. We have taken your.
Let the employer, that is the PNRD, take a call within a stipulated time frame. And let the writ petitioner have a copy of my lord's order, certified copy.
Along
Heard
with the copy
Mr.
of the writ
Mazumdar,
petition.
learned counsel, appearing for the
Definitely.
petitioner. Also heard Mr. R. Pujari, learned counsel, appearing, learned standing counsel, finance department, full stop. None appears for the respondent number 1, 2, 4, and 6, full stop. Although counsels had entered appearance on behalf of the respondent number 7 and 8 by filing Wakalatnama command, today none appears before this court. The grievance in this writ petition is that the petitioners who were working as casual employee within bracket tax collector since the year 1994 are working in the Gaon Panchayat of Rotabari, in the Rotabari Gaon Panchayat. And people who, the petitioners who are working in so and so have been deprived of an upgraded pay scale, although persons who were either similarly situated or had joined as in the same capacity later than the petitioners have been afforded an upgraded pay/remuneration. Full stop. The petitioners have referred to the cases of the respondent number 7 and 8 as examples to show that persons who were junior to the petitioners have been given the benefit of a higher fixed scale/remuneration while denying the petitioner the same. Full stop. The learned counsel for the petitioner has submitted that in this regard, the petitioners had preferred several representations, the last of them being
Lordship, page 30, Lordship, 30. 6 December
just a
2020.
minute.
If not,
Last of them being filed on the 5th of December 2021. Full stop. The learned counsel for the petitioner has submitted that thereafter the process was moved in the appropriate channels to consider the case of the petitioners for grant of relief. However, there has been no finality in the matter and therefore the petitioners have preferred this present writ petition, seeking the following relief. You give the prayer clause from page 14. From page 14, prayer to Chapidibo. Next. The learned counsel for the petitioner has submitted that as per instructions received, the matter is now and has now again been referred to the Commissioner and Secretary to the Government of Assam in the Department or in the Panchayat and Rural Development Department for consideration of the case of the petitioners, full stop. The United Council for the petitioner further submits that for the present, the grievance of the petitioner would be redressed in the event the respondent number 2, that is the Commissioner and Secretary to the Government of Assam, PNRA Department, is directed to take appropriate decision in the on the representations filed by the petitioners within a specific time frame, full stop. In the case the result of the consideration is in favor of the petitioner, comma, their grievances would stand redressed at that stage itself, and if there are any further grievances, petitioners may be allowed the liberty to approach this court again, full stop. The Learned Counsel appearing for the Finance Department, comma, Mr. R. Borpujari has submitted that unless a decision is conveyed by the respondent number 2, if required with the consultation of the respondent number 3, that is the Finance Department, comma, there would be no finality in this matter, full stop. Accordingly, this court disposes of this present writ petition, directing the respondent number 2 to take a final decision on the representation and prayers made by the petitioners for upgradation of their remuneration / regularization of their services in accordance with law, comma, if required in consultation with the respondent number 3 within a period of 6 months from the date of receipt of a certified copy of this order. Full stop. The result of the consideration shall be conveyed to the petitioners within a period of 1 month from the date of the decision being taken by the respondent number 2. Full stop. The petitioners would thereafter be at liberty to raise grievances against such decision if the necessity so arises in accordance with law. Full stop. Writ petition accordingly stands disposed of. Yes, sir.
Limited, they are under the Karimganj Jilla Parishad, Lordship.
Where you said the Rotabari GP under the Karimganj Jilla Parishad.
That direction also maybe 2 and 5 also.
And now it is Sri Bhumi. Where is Karimganj?
Earlier it was Karimganj, now it is Sri Bhumi.
Which was earlier under the Karimganj Jilla Parishad and now it is under the Sri Bhumi Jilla Parishad.
Much obliged.
Yes. Anything more?
No, Lordship. Only thing is that the direction may be 2 and 5 because CEO is to communicate all these things, Lordship.
Petition disposal the respondent number 5 shall also is also directed to take all necessary steps so that the case of the petitioners can be considered by the respondent number 2 within the time frame granted by this court.
Much obliged.
Obliged. Yes.
The Lordship has sought for our presence, my lord.
We have sought for your presence because what was the matter, sir? Tell us again. You were asking for
Regularization.
No. They had applied for compassionate appointment. And they were given ad hoc appointment. Or what? Work charge appointment.
Work, sir.
Can it be so? Work charge appointment is not an appointment under the government. You do not say it is a regular or a legal appointment. You say work charge. How can compassionate appointment be on work charge? Number one. Number two, the government has rejected it because of your office memorandum saying that there will be no further regularization of work charge or other employees.
That is post, my lord, post their appointment as such, my lord, whether compassionate or otherwise. They were appointed.
No, could compassionate appointment have been done on work charge basis?
No, that could not have been done.
Now,
number one.
If that could not have been done, a correction in the mode of their appointment when it is an admitted position that there are regular vacancies were available, are still available, would would it only amount to a conversion of an irregular appointment to the appropriate post in a regular manner?
No,
Or will it amount to a regularization under your scheme?
no. Because as on today, admittedly, this person, this petitioner, why I am making that submission, I am going by the relief clause in item number 6. What has been prayed for? They are praying for, my lord, for a writ of mandamus for regularization and upgradation of their service of the petitioner to a regular post on compassionate ground instead of appointing her as khalasi, works as khalasi. So admittedly, the petitioners have been engaged as works as khalasi. So they come within the ambit of the dictum in Upendas.
Now, their language may be wrong. Let us not go by the strict language.
No,
Their
it is
ultimately the fact falls whether once they were considered under the compassionate appointment scheme, they could have been appointed as work charge. When posts were admittedly available, posts are still available for whatever reasons, for whatever to be done.
Because that is all.
Now, if that appointment as a work charge was wrong,
Yes.
and we direct the respondent authorities who had appointed them
Yes.
to take into consideration the fact that it could not have been against a work charge, and to correct their appointment by giving them whatever relief that would flow only from the date of correction of the appointment, mode of appointment.
No, mode of appointment, because my lord, rightly wrongly they were appointed. Now they were appointed, my lord, as works as khalasi, because lordship will kindly consider for appointment on compassionate ground, it is a altogether different route.
Everything was done.
Whatever.
And it ended up in a appointment letter saying work charge. That appointment letter is wrong.
Appointment letter
That is the problem. You have issued some department issued an advertisement, they have done all the process, it was regular post, regular appointment. While issuing the appointment letter, for some reason they write down work charge. It was not intended to be 3F. It was not intended to be temporary.
So far as compassionate appointment is concerned, it has to be through the tire of my lord, two-tier mechanism, DLC and
Done.
XL.
Has it been done? Yes, we are assuming it is done.
Now,
everything went through.
So
all process followed.
If there is
only the appointment is wrong.
If there was any recommendation of the SLC recommending that the petitioner should be appointed on compassionate ground, definitely a post ought to have been earmarked. I presume that the post have been earmarked. So appointment on compassionate grounds is a regular mode of appointment. Like this way, that way, whatever it is, my lord. Because it is
it is not in the regular process, but it is a regular appointment.
It has the sanctity of law.
Of law, yes.
It has the sanctity of law.
True.
Now, my lord, having done that exercise, at the end of the day, when my lord, the appointment letter was issued as khalasi, my lord, that is an irregularity. Now, that irregularity, my lord, if sought to be regularized, perhaps, my lord, because of Upendas, there will be a part. Appointment letter.
Why do you say that? Just a minute. 2006.
Because lordship will find their appointment letter. My lord, I am taking up that petition 3806, my lord, Korobi Medhi. Yes. If their lordship may be pleased to come to page 28, my lord. Page 28 is the appointment order. Now let us see, my lord, the appointment order. Notwithstanding to the seniority and without prejudice, and so subject to reversion to the and that is fixed pay without notice and without so and so, the following fixed pay worker of Dibrugarh division.
Yes, what happened prior to this? Where is that fixed pay order?
No, Lordship, we are not fixed pay worker. We applied, Lordship, our name has been generalized along with the other worker.
Which one?
Page 28.
No, page 28 says the following so and so
Lordship will see our name against the right hand side.
on compassionate ground.
Not.
Yes,
So that is why Lordship, we just applied.
we do not know whether you have been upgraded to the head office on compassionate ground or whether you are appointed on compassionate ground.
Appointed as compassionate.
Where is it?
We never applied for other purpose. We only applied for compassionate.
Those materials will have to be produced.
That
before
Lordship,
this
I have,
honorable
Lordship, I
court.
have their minus Lordship of their office. So we obtained through RTI Lordship. We have
Show us.
Lordship.
But if you keep it with you without giving them a copy.
Because these materials are not available on record. They will have to,
many
petitioner
things
will
that
have
are
to produce at least, my lord, the minutes of the SLC. Because without the minutes of the SLC,
How
there
can this
cannot be
petitioner
any.
get Lordship? This department was directed Lordship not only one time, several times.
Okay,
to
who is the department? Assam
Lordship,
Urban
I have the
Water Supply Sewerage Board.
proceeding Lordship.
Huh?
I have the copy of their proceeding Lordship.
Please.
Office
Diyorsun,
में
Bora.
देखो, okay, these are the office notes we obtained through RTI Lordship. So Lordship, the first page at the bottom portion Lordship. Srimati Binita Kolita Das, completion ground. Necessary order may be issued accordingly. This was the Lordship, minus to their board meeting Lordship. Then Lordship will have the page 4. Yes, Lordship, the page number 15, Miss Korobi Medhi, head office, serving with effect from 1st January 2010. She was engaged on compassionate ground.
Engaged on compassionate
Then
ground, my lord,
Lordship
will
will
be
have
irregular appointment.
Page 6, Lordship will see page 6. This is the item number 7, Lordship. Binita Kolita Das,
Item number
7. Binita Kolita Das. Not according to the seniority and without prejudice, to also the subject side, to the revision on the original place. That is fixed pay without notice and without assigning any reason.
what is the last line?
Lordship,
What is the last line?
this engagement shall, however, not entitle her to have any future claim to their regular appointment. So that line is there, Lordship. So basically,
In the year 2009, it was there.
yes, basically, Lordship, when appointment order is issued, this line is there. And after that, Lordship will see the next page of page 7. Page 7, Lordship.
They have, authorities have messed up everything. If Lordship may be pleased to come to, my lord, page 34 of the writ petition.
Page 7 is already there in the
Yes,
petition.
Page
then
34.
Lordship, page 11 is the Lordship board meeting resolution.
Because what I,
Page 37, huh?
my lord, page 34, my lord. Page 34, that is, my lord, a communication dated 22/02/2022. Lordship found it, my lord. Lordship will kindly see, my lord. It's a communication from the Assam Urban Water Supply and Sewerage Board. So that is the board wherein, my lord, these petitioners were engaged. Kindly see, my lord. Approval for upgradation to regular post on compassionate ground. I'm reading from the second paragraph. Late Padmakanta Das, UDA of this board was appointed as a regular LDA and he expired on 2009. Binita Kolita Das, that is the second writ petition, my lord, in the second writ petition, is the wife of so-and-so and she applied for appointment on compassionate ground in regular post. But she was engaged as worker on compassionate ground. This is the irregularity. So that means the exercise contemplated under law for appointment in compassionate ground has not been, has
Now
not
you
taken,
come down.
not
Now
taken
you
place.
come
Yes,
down to the
yes,
second last paragraph,
yes.
third last.
No.
Now Binita Das.
Yes, my lord, then my lord Medhi, first.
No, that we have read.
Yeah.
Come down
Sunita
to
Medhi, yes.
Binita.
Now Binita Das and Korobi Medhi has applied for regularization of service on compassionate ground. This could not be done. citing that they should have been appointed to a regular post. As per government letter number so and so, government has directed to complete the compassionate ground of appointment prior to 2017 so and so. There are 2 numbers of sanction vacant posts of regular Khalasi under grade 4 at head office. We may regularize C. Vinita Das and C. Korobi Medhi against the above mentioned sanction post in view of the above government approvably sought for. Now, regularization is not possible as on today.
But then does the duty of the government to have considered their compassionate appointment on
No, they
2022?
No,
On 2022, does it go away?
no, whether she has applied through proportional before the authority, my lord, for compassionate appointment, that is one aspect of the matter. Once that application is laid, authorities are bound to take a call. And then, my lord, the DLC will hold its meeting, district level committee. They will see the, my lord, applications and see the, my lord, examine the feasibility of the applications and then make recommendations. Those recommendations, if either favorable or not favorable, will be then again sought up to the, my lord, state level committee. State level committee will ultimately take a call. Whether that exercise contemplated under the law has occurred or not, my lord, to that extent, repetition is silent. So I presume, my lord, that that exercise had not taken place at all. Therefore, these appointments at page, my lord, 28, page 28, these are irregular appointments. And this is a board, my lord. So they make appointment at their own sweet will. Whether any selection process had taken place, merely
Is that page 47,
47.
paragraph 3.
Paragraph, my lord.
3.
3.
Third paragraph from the top.
Yes, autonomous bodies, institutions, including municipal so and so under the may adopt this policy or formulate such policy for compassionate appointments in the line of
Now
yes.
Compassionate appointments, since they are not the government directly,
Yes.
they are with the board.
Yes.
So the government had, so the board had to frame its own policy.
Yes.
So they have applied to the board.
Yes.
And the board cannot have a SLC or a DLC within themselves.
Yes.
They would make the recommendation. Therefore, that recommendation had to be considered by the Department of Housing and Urban Affairs by giving an approval.
Yes.
They did not do it in appropriate time.
Yes.
They rejected a regularization under the finance OM.
Yes.
So now we are directing the Housing and Urban Department to take a call on that letter of the this thing. What to say, the of the board.
Of the board.
Asking for approval for compassionate appointment. That is 22 to 2022. The board will take the appropriate decision on that.
The board will take the appropriate, but
because that decision.
Yes, but my lord, with all
your scheme says the board will formulate and the board will appoint. We cannot expect the board to have a SLC or a DLC.
No, board will formulate, my lord, but ultimately at the end of the day, my lord, the regular scheme for appointment under compassionate ground will have to be followed, my lord.
Cannot be, because here at 2015.
Yes.
That whatever scheme you had given, where is that scheme that we just read?
Page 47.
Page 47. Page 47, which is the scheme.
Yes.
Says the board will have its own scheme.
This is the, my lord, original compassionate appointment scheme, which have been approved, my lord, in Osutronson Das and my lord, Fazarion Nessa.
Yes.
It has got
therefore, para 3 has also been approved.
Yes, para 3.
So therefore, the board would have its own scheme.
Yes.
Therefore, the board will do it, and the industries department or public enterprise department will issue suitable directives.
No,
if it is absent, whatever they have done will go to the parent department. The parent department has to take a call on 22 to 2022. Not reject their case of regularization.
That is true, but first and foremost, they will have to frame a policy.
Whatever they want to do, however they want to do. We will direct the respondent number. Who is he? Who rejected it?
2 lawsuits, joint secretaries.
The government of Assam in the Department of Housing and Urban Affairs will have to take a call on the letter dated 22 to 2022, page 30. What is this? 4.
Yes. Because by this letter, their posts were sought to be regularized.
Not only regularized, they were sought to be that compassionate appointment they wanted to give.
Yes, compassionate appointment. But
On
now,
compassionate ground. They were already working as work charge. Now let us appoint them on compassionate ground is what they wanted to do.
what
Terms used may be different.
Yes, therefore, what I understand, my lord, is that they will have to formulate a policy.
Whatever the department wants to do.
Because by now, lordship
Whatever
is,
the department wants to do.
therefore, lordship is also aware, my lord, by now a notification has been issued by the personnel department that no more compassionate. Because,
Could be, but
because of
this
the.
has to be answered.
They will
Only
have
once
to
it is answered saying no, he can come back to the court and say that it is a process prior to the notification, whatever he wants to say.
Otherwise, let the authority, let that, my lord, respondent authority, pass a speaking order.
And that is what they do. That
Yes.
is what I'm saying, that
Yes.
22-2022
Pass a
has to be
speaking
disposed
order.
of.
Yes. Dispose of this, yes, by passing a speaking order.
By stating whether they are entitled to a compassionate appointment or not.
Basis of this notification, this letter, lordship 22-2, already they have passed this order at page 14.
We are setting it aside.
Yes, citing that notification.
We are setting it aside,
Lord,
saying that this is not a case
Lord,
where they were required to
Lord.
consider your regularization from one post to another. This letter was a letter which said that you were appointed on compassionate, you were appointed as work charge on immediate compassion, and since posts are available, can further regular compassionate appointment be granted to you.
Now,
And that is the decision that the department had to take. Not taking that decision is wrong, and therefore they are required to take that decision.
also taking into account, my lord, whether as on date, my lord, regular vacant posts are available. Because
We
at the end
discuss
of-
here, we don't guide there. We'll discuss it here, we will not guide them
Yes,
there.
yes, yes.
Huh? When we are trying to make a leeway to walk, should we be building walls?
They have messed up everything.
So we'll try to clear it.
Yes.
Heard Mr. J. Kulta, learned counsel appearing for the petitioner. Also heard Mr. Arbor Pujari.
No, my lord, finance is not a party here.
Finance,
Sorry,
sir, you are appearing for?
finance is a party, lordship.
No, our name
Who is three? Ah, yes. Who appears for 1 and 2? 1 and 2, sir. So what do you say?
No, that is the way appointment procedure. They have the rightly of the appointed person. But regulation is now is not possible.
No, the regularization issue was never there in the letter dated 22-2022. What the board had asked the government is, sir, we have already, we have work charge, we are allowing them to work. They are praying for for compassionate appointment. We have the posts. Please tell us, can we appoint? And the department says no regularization.
Yes.
They don't want a regularization in that mode.
That is the problem.
If their work charge employment, whatever has gone, has gone. Since the compassionate appointment, 2 posts were available and you were required to take a decision at that point of time.
As compassionate appointment, there is a procedure, my lord. That procedure is not followed.
No, that procedure for the board. So far as the board is concerned, they will have their own procedure.
No.
That is what the scheme says. So the board says, we have followed our procedure. Please appoint. You are not doing it.
If the board are taking their own procedure, they have appointed on compassionate ground.
No, they have not appointed. They have asked your permission to appoint.
Appoint.
And you did not refer to that.
Yes,
You did not answer that. You answered something else.
Depending upon the finance department.
So answer the board's query. Can it be approved?
That is the problem.
If you say it can be approved, they will get an appointment. If you say it cannot be approved, we will meet Mr. Kolita again on a different number with the same names. Mr. Disciplinary and counsel appearing for the learned senior counsel assisted by? Have someone? Assisted by Mr. So-and-so. Read your name, she misses it out. Mr. J. Chutial and counsel appearing learned senior counsel assisted by Mr. So-and-so appears for the respondent number 1 and 2. Your name is? On behalf of Mr. S.P. Chaudhary, appears for the respondent number 3. The present writ petition has been filed by the petitioners who, 2 writ petitions are there. 2 writ petitions.
6 and 7 laws.
The present writ petitions have been filed by the petitioners who claim that on the death of the sole bread earner in their family, comma, who were serving under the, what is that board? Assam Urban Water Supply and Sewerage Board, comma, the petitioners had applied for appointment on compassionate ground in the aforesaid board, full stop. The learned counsel, Mr. J. Kulita, appearing for the petitioners, have submitted that the petitioners were initially appointed as Khalasi within bracket work charge, both of them?
Both of,
Both of them?
both of.
Work Khalasi within bracket WC work charge and were posted full stop, while the petitioner in WPC number 3806 of 2022 was posted to the head office, comma, the petitioner in, what is the other number? The item number 6, huh? So and so was posted, was also appointed as a work charge Khalasi. Full stop. The petitioner in item number 6 was appointed by the order dated 5/5/2010, while the petitioner in the other item number 7 was appointed on 25/11/2009. The petitioners during their course of service had preferred a representation to the concerned authorities, praying that their candidature may be considered for appointment on compassionate ground on regular basis against vacant post of grade 3 and grade 4, according to the qualifications of the petitioners, full stop. The representations of the petitioners were taken up by the concerned department, department and the respondent number 1, acting through the Joint Secretary to the Government of Assam, Department of Housing and Urban Development, had required the respondent number 3, acting through the Managing Director, to submit the proposal along with justification and detailed documents for taking urgent action from the end of the government, full stop. By a communication dated 22/2/2022, the respondent number 3 had informed the government of Assam that there were 2 numbers of sanctioned vacant post of regular Khalasi under grade 4 at the head office, where the petitioners could be regularized, full stop. A permission was sought for, or an approval was sought for from the government for upgradation to the regular post as applicable, considering their experience and qualification on compassionate ground. Full stop. By the order dated 2/4/2022. Is it?
No, Lord. Rejection order.
Huh?
Rejection order 20.
Or 25
May.
2022, huh? 25 2022, comma. The government of Assam in the Department of Housing and Urban Affairs had rejected the proposal for upgradation to regular post in respect of both the petitioners. In view of the Finance Department OM number FEC, you will find it at page 40, underlined, huh? And so dated 16/6/2012, full stop. Next paragraph. The learned counsel for the petitioner has submitted that the petitioners had applied for being considered for compassionate appointment in the year 2010 and
6 and 9.
in the year 2006 or 2000, not 10, it is 2009. And
7 is 9, 6 is 10. 6 is plus 6. Item number 6 applied in 2006. Item number 7 applied in 2009.
the petitioners had applied in the year 2006 and 2009 respectively. And instead of being appointed on compassionate basis on compassionate ground on regular basis, comma, they were given immediate succor by allowing them to work as work charge khalasi. Full stop. The learned counsel for the petitioner has submitted that the petitioner's cases had to be ought to have been considered for appointment on compassionate ground. And from the tenor of the letter dated 22/2/2022, it appears, it is apparent that the managing director of the respondent number 3 had indicated that 2 numbers of sanctioned vacant posts under which the appointment of the petitioners on compassionate ground could be considered. Full stop. By drawing attention of this court to the office memorandum dealing with compassionate appointment dated 1st of June 2015, the learned counsel has submitted that the autonomous bodies, institutions, including municipal corporations, cooperative institutions, universities, under the control of the government may adopt the policy or formulate such policy for compassionate appointment in their services on the lines of compassionate appointment under the government. Concerned departments were required to issue suitable directive to the various public sector undertaking for adopting such policies. Full stop. The learned counsel for the petitioner has submitted that the attempt of the municipal board to have the cases of the petitioners considered for compassionate appointment pursuant to their for compassionate appointment on regular basis pursuant to their applications have not yet been decided by the concerned department, and the petitioners still continue to work as work charge khalasis. Full stop. Next paragraph. The learned counsel appearing for the respondent number 1 and 2 has submitted that the letter dated 22/2/2022 had prayed for a consideration, had requested a consideration for regularization of the services of the petitioner, and therefore, in view of the office memorandum dated 16/6/2012 issued by the Finance Department, comma, such no positive consideration could be given to the petitioner's case. Full stop. Having heard the learned counsel for the parties and having considered the materials placed on record, I am of the opinion that the petitioners had been given an immediate succor by way of appointing them as work-charge khalasis to overcome the loss of the only sole bread earners in their family, and their cases for compassionate appointment had remained to be considered in accordance as projected in the communication dated 22/2/2022 full stop. The Assam Urban Water Supply and Sewerage Board is a government of Assam undertaking, and the managing director of the board had forwarded the proposal of compassionate appointment of the petitioners to the government seeking approval for regularizing their earlier appointments and for regularizing their appointments on compassionate ground full stop. In essence, I am of the view that the concerned department was required to have considered as to whether the two petitioners in the two writ petitions could have been considered for appointment on compassionate ground rather than a consideration for regularization of their services from work charge khalasis to regular posts of khalasis, as has been sought to be denied by the impugned order dated
20 May 2022.
25/2022 full stop. In view of the above, since the communication dated 20 May 2022 does not deal with the request of the respondent number 3 to consider the appointment of the petitioners on compassionate ground and has rejected the proposal for upgradation to regular post, full stop. The matter is now remanded back to the respondent number 1, who to the respondent number 1 to the Commissioner and Secretary of the Government of Assam, Department of Housing and Urban Affairs, Assam Secretariat. Don't write Assam Secretariat. The Department of Housing and Urban Affairs, Assam, to consider the letter dated 22/2/2022 in the proper perspective and take a final decision on the entitlement of the petitioners to be considered for appointment on compassionate ground, in accordance with the law prevailing, law. The decision to be taken by the Commissioner and Secretary to the Department of Housing and Urban Affairs shall be communicated to the petitioners within a period of 2 months from today. Stop. The petitioners would be at liberty to
2 months from the date of receipt of the certified copy. 2 months from the date of receipt of the certified copy. Not for
2 months from the date of receipt of a certified copy of this order, full stop. The petitioners would be at liberty to submit the certified copy of the order of this court along with a fresh representation citing their grounds which they sought to take up in this writ petition for appropriate consideration by the competent authority. So writ petition disposed of. Let them say their yes or no.
Absolutely, absolutely. And because that is the gray area which is required to be answered.
That is what if it is regularization, it's a no. It is a straight no.
No, Lordship.
If we can drag it to the compassionate appointment area, then it is a perhaps.
One fair lordship is there. Until passing this order lordship, this petition not be lordship, no coercive action will be taken to remove this petition from service lordship. That much may be real lordship.
It has been submitted by the learned counsel for the petitioner that the petitioners continue to serve as workers khalasis. Full stop, it is expected that the respondent authorities would not take coercive action against the petitioners while deciding their representation
Special drive.
as directed by this court.
Lordship. All this special drive is going on lordship to remove this workers employees. That is why I'm playing lordship. The special drive is going on in the department lordship to remove this workers employees. That is why I'm playing this.
No, if you are in that drive, then you will be driven.
They may be misinterpreted.
If you are in that drive, then you will be driven. That we cannot help. But because of this litigation, you will not be thrown out. That is what we can.
Yes. Obliged.
Disposed of. Both the writ petitions disposed of. Common order. Huh? At the top, you write this common order would govern the both writ petitions, WPC number so and so and WPC number so and so.
I received the documents that I have submitted.
You give back the documents. What documents did you give? Idea anything. Yes.
May it please the Lordship. Lordship, in terms of last order dated 5/8/25 passed by this honorable court, the Office of Accountant General has authorized Treasury Officer Aflong for making payment of DCRG to the first wife and the second wife, 50% each. And to that effect, we have filed our affidavit in opposition today, Lordship.
Are the children minor?
Lordship.
All the children are minor.
No.
Huh?
But
all are major. Okay. Then they are not entitled to DCRG. You are who?
8 to 12.
8 to 12. Let us not open the Pandora's box. You have filed there?
Affidavit of opposition today, Lordship. Lordship.
Your name, sir?
A. Borua, on behalf of Mr. C. Borua.
Mr. A. Borua, appearing on behalf of Mr. C. Borua, Learned Counsel for the Accountant General Assam, has submitted that an affidavit has been filed today. Full stop. The records of the case do not contain the same. Full stop. Accordingly, this matter again on when? July. July did you on so and so July. On which date the parties would be at liberty to apprise this court whether the DCRG amount has been released. 29th of July.
Maybe Lordship, the petitioner is eligible for financial upgradation with effect from 1/1/2018. Denied by the respondent authorities, Lordship. In the pretext, Lordship, I am referring the Annexure G, page 30.
You want some upgradation?
Upgradation, Lord.
From where to where?
I'm eligible from 1/1/2018.
For what? Upgradation of post or MACP third?
Financial upgrade.
MACP third?
Financial upgradation.
MACP third.
Yes. Lordship.
So why are you not being given?
And that is Lordship, Annexure G, page 13.
Annexure G, page 30, yes.
Page 13. They have said that so and so with reference to the above service book so and so, pay fixation recorded in your service book with effect from 1/7/26 to 1/7/2020 was wrong. On the basis of the audit report, salary to be drawn and already drawn amount were calculated considering the third financial upgradation benefit. Salary overdone were observed. So there is no liability of the division to pay any area salary amount till that.
It is a plea taken by the respondents authority. And against this, Lordship, they have filed their affidavit. In affidavit, Lordship.
Sir, we have not even understood when you joined your post, why should you get your
Yes,
first,
Lordship.
second and third
No, Lordship.
MACP? When did you get it?
Lordship.
Why do they say that there is no area available? What was the wrong? Tell us
Lordship,
something more.
I'm referring, Lordship, the annexure D, page 21.
Annexure
D, page 21.
21, okay.
21.
Yes.
So this is the office order, Lordship. I'm reading it, Lordship. On recommendation of DPC 4, meeting held on 19 to 21, the following 55 numbers of retired employees. I'm already retired in 21, Lordship.
Okay, petitioner retired in 21.
Yes, 30.
When did you join your service?
I was thrown in service, Lordship.
Prepared? Yes, sir. Place this matter again after a week, allowing the learned counsel for the petitioner to prepare himself with the brief. Yes? Prepare yourself with the brief. When you are asking for financial upgradations of the benefits thereof, you should have been stagnated on the same post for a period of 30 years before you can get the financial benefit.
Let me make a clarification. The financial upgradation we are not denying. In our affidavit, we have.
Whether any area salaries.
Yes, in fact,
you are
after
not.
computing the financial, after giving him the benefit of the financial upgradation, it was found out.
Was it given on the correct date?
It was not given, initially it was not given on the correct date, but before that, he was given a irregular financial upgradation, which had to be withdrawn. So after deducting both the figures, the audit department came to a conclusion that he had in fact overdrawn an amount of 61,000.
Then you help us.
My lord.
Tell us, when was the first financial upgradation required to be given? When was the second required to be given? When was the third required to
The
be
first was rightly given, your lordship. First was given on 1/7/2006.
2006. Okay.
My lord, second one, then in 1/1/2007, he was given the benefit of the next higher scale. Then on 1/4/2016, your lordship.
Just a minute. Second comes on 1/4/2016.
1/4/2016, he was given the next second revision. And as per the audit report, he was supposed to get the third, your lordship, financial upgradation from 1/1/2018, which was not given to him.
2018.
1/1/2018.
Okay.
Now, as per the stand taken in the affidavit, there was a financial upgradation given to him on 5/9/2004 earlier, which was irregular, which should not have been given to him.
Okay.
And since that was irregular, those amounts had to be adjusted against this benefit. After adjustment, it was found that he had overdrawn an amount of 61,926.
Because of your
5/9/2000.
Because of the irregular upgradation given on 5/9/2004.
My lord.
Okay.
And because of that, even if we have given him the benefit, there are no amounts due that have to be paid from our end to him, your lordship.
And what about the 2018, the third one? Did he get it at all?
Yes,
did he get it?
The 1/1/2018, he did not get, my lords.
That was given after retirement.
That was given after retirement.
After retirement.
After retirement.
Yes.
Yes, Your Lordship. That is
Do you deny you were given something in 1/1/2004 or 5/9/2004?
Yes, but whatever their plea of overdrawn, they've only informed me after my representation, not earlier.
Okay.
Lordship. Lordship, my representation is on page 29, annexure F. Page 29, annexure F.
Yes.
So this is my representation. Against that representation, Lordship, prior for granting financial upgrades as per recommendation of DPC so and so, Lordship. So, therefore, I request kindly take necessary steps to release my entitlement financial upgrades benefit with effect for 1/1/2018. So against that, they have made a reply, this annexure G. After my retirement,
Yes.
they have that due to the overdrawn, so that I am not eligible for.
Then kindly show us that it was correctly given to you on 5/9/2004.
Then 2004. Lordship, that is why
That a financial upgradation was wrongly given to you. From where do you say that, sir?
My lord, it is mentioned in our affidavit in opposition.
No, you never gave him that letter. You did not tell him prior to this litigation that
Yes.
this is
No,
the
no, in
period
fact,
where.
this document which my learned friend was referring to, it is a part of his writ petition.
No, I'm not on that. When you are saying that there was a irregular upgradation given
don't
in the
believe
year
so.
2004,
My lord.
he was not informed about it.
No, my lord. It was come for the first time, to my knowledge, in the affidavit in opposition. Perhaps if he believes that this is wrong, then he will have to challenge this.
Yes.
definitely.
Now that you know about this, you have to show to the court that 5/9/2004 was correct. If you can show that the upgradation on 5/9/2004 was correct, then we will hold their stand in the affidavit in opposition to be wrong and you will get your relief. If you cannot show 5/9/2004 is correct, then your writ petition goes.
Lordship. So, Lordship,
You know about 5/9/2004, you have not challenged it.
Lordship, 1 week time may be given so I clarify my points also.
Perhaps it will be a fresh cause of action, my lord. Perhaps it will be a fresh cause of action to challenge. I mean,
That-
separate cause of action, not fresh.
That is why I had said let him prepare.
My lord.
I had said let him prepare. I was giving him 1 week time
My lord.
before you started.
My lord.
Heard Mr. Swin Council appearing for the petitioner also heard Mr. A.P. Pathak, Learned Counsel appearing for the
APDCL.
APDCL.
My lord.
Ms. Pukon appears for the AEGCL. Full stop. The stand taken in the affidavit in opposition by the respondents is that the petitioner had been given a irregular financial upgradation on 5/9/2004,
My lord.
which resulted in a higher grade of pay from that day onwards. And when, full stop. Therefore, when the final financial upgrade, therefore, when the third and final financial upgradation under the MACP scheme was given to the petitioner, comma, on a calculation made on the behalf of the objections raised during the audit, comma, the respondents found that a correction of the irregular financial upgradation given on 5/9/2004 and would result in a situation where the petitioner would not be entitled to any arrear salary on being granted the financial upgradation of a third financial upgradation of the MACP scheme. List of the Learned Counsel for the petitioner has submitted that he would have his instructions on the aforesaid submission made and he would require some accommodation for the same, full stop. Accordingly, let this matter be listed again after 2 weeks, allowing the Learned Counsel to have his instructions. Unless you challenge that 5/9/2004 or that audit report, or you show us that 5/9/2004.
Deeply open.
2 weeks, no fixed date. So we fixed it.
Well, here I need some time to the process, completion of the process tunnel. Actually, the proposal sent by the college
What
authority.
is this? WPC.
7786.
When did you retire, madam?
Lordship, 39/2018.
18 you retired.
Yes, Lordship.
And the area salaries for the period?
Lordship, 01/02/2007 to 28/2/2010. And Lordship, 01/03/2010 to 28/2/2014.
So now, sir, with that writ petition was filed in the year 2022.
2022, my lord.
And director is sending the proposal now.
No, my lord, what happened in between, my lord, some document, if my lord sees the annexure for page number 41, 40,
Page
those are the
number
documents, my lord.
41. Let's explain the delay.
Some documents were called, director asked for some documents from the college authority, my lord. Thereafter, verification was done. Now, my lord, this verification, entitlement of the petitioner, my lord, that verification has been completed in the directorate level. Now, this proposal will be sent to the government, my lord.
When? When?
My lord, within a week, I think.
Within a week.
But kindly give me 3 weeks time, my lord. I'll bring the status, updated status, my lord.
Lordship, already same retired assistant professor has been released. Lordship, already they have taken time.
Same?
Same one professor.
For another person, it has been released.
Yes, Lordship.
Yes, are you delaying it because of the litigation?
No,
sir?
no. What happened,
That
my
is
lord?
our allegation.
Earlier, 2 writ petitions were tagged together, my lord. The name of another person was Sanat Kumar Dev, same from the same college. The department has sanctioned his amount, my lord, recently. Now his case is also going on under process, my lord.
It is there. The writ petition, the same writ petition. So there the sanction has come, maybe your other client will get the money.
In that case, my lord, sanction was already done earlier. Here in this case, we were just verifying whether the petitioner is entitled.
We will list it in the second week of July after the reopening.
My lord.
Lordship.
Yes. Your name?
Miss Arrear, Lordship.
Learned counsel appearing for the petitioner has submitted that the respondents have been heard Miss So-and-so, learned counsel appearing for the petitioner. Mr. Das,
Yes,
learned
Das.
counsel appearing for the higher education department submits that he is under instructions from his department that the proposal for releasing the payment of arrear salary in respect of the petitioner herein has been verified at the directorate level and is in the process of being moved to the government in the higher education department for necessary sanction and stuff. You have any role to play in this? Do you have any role to play? Miss So-and-so on a counsel appearing for the UGC has submitted that the affidavit has already been filed on behalf of the UGC. Stop. The learned counsel appearing for the higher education department has sought for an accommodation of 3 weeks to inform this court the status of the proposed sanction of arrear salary. Full stop. Please this matter again on the reopening or date of July? July reopening. 27/2026.
May it please, my lord.
Yes.
Lord, we have filed an additional affidavit, lordship, whether that is on record, I couldn't check it.
12/5/2026.
My lord.
It is on record.
My lord. And on matter pertains to selection for the post of Anganwadi worker. Lordship, pursuant to the advertisement, Lordship.
Are you ready? You can,
For filing the reply, we have to wait for 2 weeks time, maybe 20.
reply by whom?
They have filed the additional affidavit and we have to file the reply. So 2 weeks time, maybe
Additional
20.
affidavit only pertains to certain documents, Lordship, nothing.
Which which it is not required by them to verify.
Lordship, they are to, Lordship.
Are they required to verify it?
Lordship, they are requests.
Your name?
SR Das on behalf of
Ms.
AT
Stardust, General Counsel, appearing for
on behalf of AT Sarkar.
For the respondent number
5.
has submitted that they have received a copy of the additional affidavit filed by the petitioner recently and would require an accommodation to have instructions on the same. Full stop. Accordingly, list this matter again on the when? Do not the 30th. Any stay operating?
Lordship, no.
17th of June.
Lordship.
Ms. Das appears for the, sorry, S. Borua appears for the 1, 2, 3. Difficulties, many a times we remember by name, we confuse of the title. And then Ms. Borua to have her. You have filed your affidavit. Has submitted that she has filed the affidavit on behalf of the respondent number 4.
Last time.
Lordship,
madam.
wait, please. Is Lordship will be kind enough to expand this part, my lord?
Which part?
Regarding paying costs, my lord. 15 we file a review application. Some technicalities your Lordship is also aware of, my lord, how the, yes, we serve copy on them. Lordship, main case be, and we have filed our affidavit in both the cases. Let these matters may come up for admission hearing on a particular date, your Lordship.
No, you are already exempted from paying the cost.
No, unless your Lordship reviews that
No, no,
order.
no. It says by order dated 9/3.
Yes, but not by your Lordship. That observation is there. Observation is there. 90
They would not be
2026.
required to pay the cost as imposed by this court.
90 2026. Yes.
Para 4.
Para 4. Mr. B.K. Das, learned counsel for the petitioner fairly
No,
submits.
the end part.
Yes.
Last 2 lines.
Accordingly, they will not be required to pay the cost imposed. So unless your Lordship, it's your Lordship's order.
Which,
Lordship need to review it.
which order?
Lordship, it's at page 14 of the review application.
This is a review application.
My lord.
No, we have a WPC before us.
No, it's there. Review application hasn't been one. Excuse me.
Borua. কিবা রিভিউ এখন ফাইল কৰিছে কৈ ৰিভিউ
ৰিভিউখন অহা নাই নেকি?
নাই লিষ্টত দেখাইছে জানো
নাই দেখোন।
not in the list
ৰিভিউটো দেখুৱা নাই ন?
you should have mentioned in the morning you could have called
Oh,
for the
Lordship,
review.
overlook. Stuck in a traffic jam for 1.5 hours, your Lordship. May come up along with the review.
List again on Friday with the review
My lord.
petition. Stated
Not
to
on
have been
Friday, on Monday.
filed on Monday along with the review petition stated to have been filed by the
Oh, he'll not be available.
PTC.
on Monday. Not this
you-
Friday.
would
It
you
has
object to the recalling of the order?
Maybe tomorrow.
No.
then.
My only prayer is that, that the matter may be,
It will not, if we take up the review tomorrow to recall only that part of the order, tomorrow, day after Monday, we are not taking up the matter for disposal on that very day itself. You can have it fixed on the next week, anytime.
then Monday,
Huh?
Monday.
It will be on Monday.
Those three matters, my lord, otherwise, my lord, they have filed their affidavit. And my lord, they are admitting.
Let us do it this way. Without the review petition, we are recalling that order. Start.
So it is your lordship's.
Number 29.
It is up to.
Lordship may come up on Monday. I don't have the number. of the
You
review.
don't need the number. We are recalling it in any case. Yes, tell us. What is your case?
My lord, may I very briefly explain the fact of the Christmas?
Please.
My lord, the petitioners was appointed in the year 1999, my lord, along with other bits of my lord, teachers in the various area of the my lord, areas under the PTC, my lord. And thereafter, my lord, their services were terminated in the year 2010, along with another batch of teachers. Thereafter, my lord, they have my lord approved before my lord, learner single bench by my lord challenging their termination orders. The learner my lord single benches had my lord rejected their my lord rejected their claim, and my lord did not interfere with the my lord termination orders. Thereafter, that my lord the petitioners along with other my lord batch of my lord teachers, there is a number of my lord writ petitions were moved my lord at that moment of time. My lord,
Have you seen their affidavit?
my lord,
Have you seen their affidavit?
my lord, yes, my lord,
You've read it.
my lord.
Does it oppose your prayer?
My lord, in two cases, my lord, there is two cases, my lord. That my lord, they are saying that in a in this case, my lord, they are saying that that admittedly that the 1300 similarly situated teachers were appointed, and their service was regularized, and my lord, they are receiving their salaries. And other writ petitions also, my lord, they are saying that they are my lord, contemplating to send a proposal for
You are
SI.
in writ petition, we are in writ petition 3106 of 2023.
Okay, my lord.
Yes, madam, your affidavit says that you will be moving the proposal. The affidavit which has been filed.
My lord. So subject to approval by the finance
So
department.
you will do your part. That is
Yes,
what
Lordship.
they have said.
They're
What is your prayer in the writ petition?
My lord, my prayer is to my lord, withdrawal of termination order, because my lord, as per my lord, while that my lord,
Where is the termination order? So you are not prepared as of now.
the termination orders is
Termination orders.
42.
Wait, Resignation, 41 to 44, if I'm not wrong.
Yes, my lord. 41 to 42, my lord, termination order.
Depend on what does.
So while you were terminated, other people were regularized. Is that your case?
My lord, that is not.
What is your case?
The case is that, my lord, all the my lord, batch of those teachers whose my lord, who have approached before the learner single, but learner single base has not my lord, interfered with the termination order. They have approached before the learner division bench. My lord, during the course of hearing of the learner division bench, that the state government council and my lord, along with the council of DTC has my lord, submitted that they are my lord, contemplating to formulate a policy. Those teachers who are regularly getting their salaries up to 2006, their service will be regularized. And considering that aspect, my lord, the policy was formulated and court has given issue a direction, my lord, that on basis of their submission that all those teachers now verified, and my lord, all those teachers who are the filling this my lord, criteria of 2026 who are regularly getting their salaries, their services will be regularized. My lord, now, my lord, we have my lord, filed writ petitions. They have verified, my lord, that the DOB.
Now, where is that writ appeal order?
My lord,
Disposal of the writ appeal? The order part?
On my lord, page 265, my lord.
Lordship, I don't find their order of termination. Whatever he has annexed, don't tell you the names, my lord.
Yeah.
First one, 41.
How
It's
many
there.
petitioners
Nuruddin Ahmed. Yes. 41.
Four.
Nipendona. Sorry, I'm so sorry.
There is there, my lord.
Now, in the writ appeal, where the termination orders set aside,
Well, termination orders was not set aside in
only the respondents were required to go ahead with the policy,
policy, my lord. And
with the policy decision and consider the cases for
my lord,
regularization.
who were getting the
Now they say that your cases
Yes.
are also being considered.
yes, my lord. They
Why
have
don't we close this petition?
yes, my lord. They have my lord. The DO, BO, and the Treasury officer has issued certificates. They have my lord. They are
And that
certified.
is all. What has been issued, we are not concerned with.
The my lord, records are there.
They have given this affidavit saying that your cases will be considered.
My lord, that is my cases. They are saying that they are in another case, my lord. In this case, my lord, they are saying that they are my lord the 1300
Do
number.
you have WPC 3106 with you, sir?
My lord, my lord.
You have WPC 3106
Yes.
with you? And
Yes.
WPC 3106, the affidavit says decided to regularize the present petitioners
Yes, my
at
lord.
par with
Yes.
their similarly
I'm sorry, my
situated teachers.
Yes, my lord. is correct.
Subject to availability of posts. There has to be
Yes, my lord,
post, there has to be sanction.
Detailed proposal to the BTC N for the regularization as assistant teacher in vacant post, answering deponent that the said exercise will be carried out as and when the BTC receives approval from finance SIU against the proposal.
Yes, my lord is correct.
What is to be done?
My lord, only all with due respect, my lord. My only one contention, humble submission is that my lord, that the procedure they have initiated, my lord. They have my lord, inquired, verified, and document were issued, my lord, out of the my lord, same list with my lord, similar findings. And my lord, it is very apparently there in the record. They are saying that we are getting my lord, regular salary not to my lord, 2006 to till 2011, and from the same list, my lord. The other similarly situated candidates has my lord, their termination order was my lord, withdrawn.
Wait, show us the letter. That is the first.
Twinkle was
that is-
sleeping over his rights.
That is what we have asked you.
I'm not sleeping, my lord.
Answer us.
My lord.
Don't answer within yourselves.
My lord.
We are asking you, show us the sentence in the writ appeal that the termination orders were interfered with. Show us an order which says that yes, the termination orders are being withdrawn. If you show us these two things, we will ask them to withdraw it like it was done for the other people.
Oh, my lord.
If you cannot show that,
My lord.
we will ask them to only proceed with the policy decision to forward your cases for regularization. Individually, if you are found fit for regularization, you will be regularized.
Yes, my lord.
With or without the termination orders, your services will be regularized. How they do it is their headache.
Yes, my lord.
If you want an order from this court,
My lord.
that the termination order is required to be interfered with.
My lord, withdrawn. No, my lord,
Withdrawn.
Oh,
How
well,
do we
in
do that?
persons
How
to
do
the-
we direct them to withdraw something?
in persons to the policy.
Where is it? Where does the policy say that I'm going to withdraw all
My lord,
matters?
because my lord, they
Where does the policy say that the
Bhupinder Najar,
withdrawn
এগাল মানে করেছিল।
my lord,
termination order should be withdrawn?
my lord,
হুম।
what I understood is that my lord, they said that those teachers who were getting the regular salary till 2006. Well, my lord, man, let them, my lord, issue, my lord, let them, my lord, consider my claim. Because why I'm my lord, submitting is that, my lord, it is my lord, third round of
Please
litigation.
again on Monday, Monday, along with review petition numbers. What we ask you, you are not providing us.
Lordship, on whatever stand we have taken the affidavit in terms of the Lordship may dispose of,
We'll dispose
but
of
with
the-
the contention is done, no stipulated time be granted. Because BTC has taken a stand, they will send a proposal, there has to be sanction post and subject to approval of SIU approval from the finance department. So
Finance department is a party in this case.
finance part.
Finance is not
On-
party, man.
Will if you had my
Finance department approval, that's subject to that approval.
We'll
Finance-
direct them to send a proposal within a certain period of time. Thereafter, it will go to the
Well,
finance is a
finance
necessary
will take their
party.
own sweet time.
well,
Party বনাই না।
Nice cup of tea with lemon. Your file will be
Green tea?
considered.
বনাই লো finance.
It's list on Monday,
আর হবো না হবে।
along with the review petition.
that is true.
kindly find out the filing number and give.
Yes, I'll provide.
Stated to have been filed by the petitioner by the respondent BTC, BTC authorities, wide filing number dash করে থাক না? Unless you give the number, we won't have the order.
Oblige your lordship.
Just for the time
Yes,
being.
sir.
Just for the time being.
Huh?
Just for the time being.
After some time. After time being কেটা আছে? Yes, sir.
May I please, your lordship, my lord, in this case, my lord, several occasions, my lord, Upon Affairs Department took time to file affidavit, my lord. Kindly see the order dated.
Yes, madam.
29/8/2020.
You don't want to file the affidavit in opposition?
Lordship, yesterday we have got one instruction from them that
From?
Assam Urban Water Supply and Sewerage Board, Lordship. That's Silsor Water Supply Scheme has already been transferred to Silsor Municipal Board along with men and materials and liabilities. And the petitioner, who was the master roll workers, Hussein Ahmed Chaudhary and others, initially engaged at Hailakandi and Silsor Water Supply Scheme. And while the scheme Hailakandi and Lala became defunct schemes, subsequently they were engaged at Silsor Water Supply Scheme. As per the above mentioned government direction and letter, they have handed over to Silsor Municipal Board and they are no longer MR staff of this board, Lordship.
Okay. So as respondent number 3, Assam Urban Supply and Sewerage Board has
Handed over.
traded all responsibility and said that it is the municipal board who will do it.
Now, my lord,
Okay, yes.
municipal board has filed their affidavit. They are saying that the petitioner are not the employees, are not their employees. They do not have any responsibility.
How?
Lord,
Who is appearing for the board? You are appearing. You will have to discuss amongst yourselves. Huh?
Let them file their affidavit.
And you file your affidavit. You have to file that affidavit saying that they are not our employees anymore. Responsibility is municipal board. And you have to give that letter also. Or that agreement also, that transfer thing also. In the writ petition, you have said that they are that you are now under the Silsor Municipal Board. And how do you say that they are not your employees, sir? Where do they say that?
In paragraph number 3.
I don't understand. Do you deny that it has been, that all liabilities and employees have been transferred to you?
Lordship, not completely denied. But the
What do you deny? Which part do you deny? Huh? Some so filed an application before the Commission Secretary for continuation of the service not to hand over the services to municipal board without their consent. Said letter is annexed 1989, which was finally disposed in the same. How do you say you are employees? Do you say, do you acknowledge that they were working under you?
Previously, they were working, Lordship.
Your the Assam Sewerage admits that.
Lordship.
Please file your affidavit.
Lordship, they have now the
So you-
employees under Silsor Municipal Board, Lordship.
Just file that instruction by way of an affidavit. Huh? Heard, Mr. A.H.M.R. Chaudhary, Learned Counsel appearing for the petitioner. Also heard,
Lordship, M.M. Bora on behalf of S.P. Chaudhary, Lordship.
Learned Counsel appearing for the
Respondent
Assam,
3, Lordship,
for the respondent number 3. Full stop.
and 6.
3 and 6.
6.
3 and 6. Full stop. Give me that instruction. The learned counsel appearing, no, Miss So-and-so, learned counsel has submitted that they have received instruction to the extent that the petitioners were initially engaged at Hailakandi and Silchar water supply scheme. And since the scheme at Hailakandi and Lala became defunct, comma, they were engaged at Silchar water supply scheme. Full stop. In accordance with the government letter number U, capital U, capital D, within bracket capital N dash ACS oblique capital D small u, small o, asota ako capital likhibo HUA oblique 3 oblique 2021 oblique 36 dated 189 dated 18/10/2021, comma, the petitioners were, the services of the petitioner were transferred to the Silchar Municipal Board. Full stop. A further suggestion had been made in the instructions that parawise comments from the board may perhaps not arise. Stop. The writ petition has asserted that the petitioners were serving under the Assam
Urban water supply sewerage.
Assam Urban Water
Supply and sewerage.
Supply and Sewerage Board. And therefore, this court is of the opinion that the respondent number 3 is required to file an affidavit either admitting or denying all the allegations leveled by the petitioners against the aforesaid board. Full stop. Therefore, the respondent number 3 shall ensure filing of an affidavit with regard to the contentions raised in the writ petition within a period of 2 weeks from today. You have filed your affidavit. Yes. This is the matter again on July, did you?
In the month of June, they are not getting any salary. They are even not allotted any work also for last 2, 3, 4 years.
When do you want it?
In the month of June, my lord.
2 weeks from now, June or did you? Huh? 19 did you? 19th of June.
Deeply obliged.
May please allow, sir. My lord, a matter pertains to, my lord, a filling up the post of headmaster, my lord, at a AACB High School in Naringi, my lord.
Okay.
My lord, by considering my B.Ed degree, my lord, I obtained my B.Ed degree in the year 1995. By considering my B.Ed degree and as per the service rule applicable to the government schools, my lord, on 17/1/2024, at page 21 of my writ petition, annexure A, I was promoted to the post of headmaster, my lord. Page 21. Thereafter, my lord, the respondent number 4 file a representation before the authorities with a request to promote her to the post by considering the seniority, my lord. It is admitted that she is senior to me, my lord. Her date of appointment was 21/9/1992, and my date of appointment was 21/9/1992, and respondent number 4 was appointed on 3/9/1992. By considering her representation, my lord, the impugn order was passed at page 26.
Page
26 of my petition. There was a resolution.
Yes.
Page 26, there is a resolution adopted by the Board of Directors. In pursuance to the board resolution number 44 of Board of Director meeting dated.
Then
Thereafter, my lord, I filed this writ petition, my lord, and the stay order is operating, my lord. Now I am serving, my lord.
So what is your stand? Why was that wrong?
My lord, the first thing is, my lord, I was not given an opportunity to defend my case, my lord. And the second is, my lord, for holding the post of headmaster or for a teacher, my lord, an incumbent has to obtain the B.Ed degree, my lord. And as per the NCT norms, my lord, and the affidavit filed by the APDCL, my lord, at page 68.
Page
68, paragraph 9. Running page on it.
Just a minute.
It was
Is
filed
it
on
by, it is not by Bobita Adhikari.
28/1/2026.
Just a minute. You have got
Chiranjeev
the page-
Adhikari.
you have got the pagination wrong. Page 68.
68,
Uh,
paragraph 9. May I read, my lord?
Hmm.
That it is pertinent to mention that there is no codified service rules for teachers serving in the schools governed by the respondent APDCL. Therefore, as a matter of practice in the past, promotions were granted on the basis of seniority, and seniority is based on the date of joining. However, the promotion order dated 17/1/2024 was passed in view of the Assam Senior Secondary Education Government School Service Rules 2020, notified by notification dated 8/5/2020, wherein it is stated that candidate must be BA, BSc, BCom with B.Ed, BT degree from any recognized university possessing 10 years teaching experience as graduate teacher for promotion to the post of headmaster. Since, my lord, I have been promoted in terms of this rule and NCT, and this rule was framed in terms of the NCT guidelines. So before taking any action against me, my lord, I am entitled for notice, my lord. And my lord,
no, what happens if you are given a notice? What did you say?
my lord, I
This is
could,
just to find out so that that notice is not an empty formality.
yes, my lord.
Tell us.
My lord, in that case, my lord, my submission is, my lord, the respondent number 4, she has not possessed that B.Ed degree, my lord.
Is the possession of a B.Ed
Yes, my lord.
degree necessary?
Page 140 of my reply filed against the affidavit filed by the respondent number 4.
Page 140.
140 Annexure A.
When were she appointed?
She was appointed, my lord, on
992.
3992.
Earlier.
Earlier, my lord. I was on 21/9. She was on 39.
So
15 days
where does
earlier.
it say that you require a B.Ed?
My lord, page 140. This is the regulation of 2001 NCT regulation. If my lord turns to page 141, this is the schedule, my lord, for the Roman 2, secondary, higher secondary school, high school, graduate with bachelor education or its equivalent. Page 142. And my lord, as per my lord, clause 4 at page 141, it is stated that the existing recruitment rules may be modified within a period of 3 years so as to bring them in conformity with the qualifications prescribed in the schedule.
Page 140?
140. Clause 4, down below, my lord. Clause 4. The existing recruitment rules may be modified within a period of 3 years so as to bring them in conformity with the qualifications prescribed in the schedule. Meanwhile, teachers appointed as per the existing recruitment qualification subsequent to the issue of this regulation will be required to acquire the qualification as prescribed in the schedule. She was appointed in 1992. So as per this regulation, my lord, she had to obtain her BA degree within 3 years, my lord.
Subsequent to the issue of this regulation.
Subsequent to the issue of this rule, this rule was 2001. So by
She was
2004,
appointed in 2000 in
she was appointed
1992.
92, my lord.
So she is not a person who was appointed subsequent to
Like a
the issue of this regulation.
Subsequent, after coming to force of this regulation, my lord.
She was appointed prior.
Prior, my lord.
Then
Not, my lord,
how will 4 apply to
subsequent
her?
to issuance of this regulation.
How will 4 apply to her?
It will apply, my lord.
How?
She was appointed as per the rules existing at that point of time.
But that appointment has to be subsequent to the issue of the regulation.
My lord, in my humble submission, my lord, the subsequent to coming into force of this regulation, my lord. This regulation came to 2001. So within a period of 3 years, my lord.
Okay.
So 2004.
So you are saying that any person who was appointed prior to these rules also
Yes, my lord.
has to
acquire her BA degree
within 3 years.
within 3 years from coming into force of this regulation, my lord.
Yes. Maybe correct. Yes.
Yes.
Mohan,
To make this is my.
you are appearing for?
I'm appearing for the respondent number 4, my lords, Bobita Adhikari. Initially, when the writ petition was filed, my lords, I was not impleaded as a party, my lords. We later impleaded ourselves, my lords. And by way of order dated 14/5/25, the respondent number 4 was.
Seniority list somewhere.
Yes, yes. There are a lot of seniority is not disputed.
There is a different aspect to the matter.
Yes, my lord.
At page 70, lordship will find a seniority list.
What is the date of what is the age of retirement in the school?
60.
60.
I'll retire earlier than
60. So 2025 you were 59.
This,
how close are you to 60?
This November I'm superannuating from service, my lords.
And what about you?
February next year, man.
February next year, my lords.
And then you become the senior most.
He becomes the principal headmaster anyway, my lords. After my lords, what I'm about to submit, my lords, was the school in question here, my lords, AACB High School. It was established in the year 1986. If I may say so, my lords, this school is sui generis, my lords. It's a class of its own kind because it's neither a government school nor an entirely private school. The only reason why a writ petition is maintainable is because this school is established and maintained by the APDCL, which will be amenable under Article 12. Now, my lords, the rules which has been referred to by my learned friend refers to provincialized schools, my lord. My lords, I'll give a very brief background, my lords. RTE Act came in 2009. Thereafter, my lords, NCT was given the authority, my lords. And then 2001 regulations came into force. My lord,
came into force earlier.
Yes.
2010 came into force.
Yes, yes.
August 2010. Yes.
Now, thereafter, my lord, even after the RTE Act 2009, my lord, immediately the state of Assam did not adopt, my lord. In the 2003 provincialized service rules, an amendment was brought in the year 2012, making B.Ed compulsory. Thereafter, the 2018 rules came, and even till date, my lords, I'll show notifications, my lords, where the teachers who were appointed prior to B.Ed being compulsory, my lords, they are given opportunity to go on deputation to obtain that qualification. Now, in our case, my lords, what I'm trying to point out, my lords, all throughout, my lords, from the affidavit filed by the APDCL, my lords, lordship would see that From its inception, seniority has been the only criteria for promotion. None of the teachers were ever sent on deputation that you acquire B.Ed. In fact, they have said that no, we made a mistake. Seniority is the only criteria, and the other rules which my learned friend is referring to, my lord may check the definition of school there, my lord. Like I said, this AACB school is a class by itself, my lord. It's not a government school, not a provincialized school, not an aided school, my lord. So, stricto sensu, my lords, that for the purpose of promotion to the post of headmaster, B.Ed is a compulsory requirement.
Yes.
That would only apply to schools which has been defined there, my lord, in the Act. And
So the NCT and RT does not apply to your school.
NCT and RT applies, my lord. What I'm trying to say, my lords, although NCT rules, NCT, my lords, if I'm not wrong, 2009, 2009 RT came, my lords. Till 2012, it was not made mandatory in Assam. B.Ed. B.Ed was only made mandatory by way of the 2012 amendment, which came in the 2003 rules. So NCT was always there. Even before 2012, B.Ed was compulsory. And even now, if my lord peruses one notification, the government of Assam, my lords, the education department,
Education manual আছে না? না নতুন খন? ও পুরানখন দিব, এখন নতুন এখন।
education
support
manual,
খন আছে। Islamic class।
provincialized service rules.
এখন নাই। Just a minute, huh?
Yes, my lords.
What is this? From whom?
My lord peruses the 18 rules, my lords. Section 1, Rule 1(3).
No, no, just a minute. Just
Yes, sorry.
No, yes, 21.
What are the classes available in the school?
It's a high school.
High school.
1 to 10.
1 to 10.
Yes, yes.
If you will come back after lunch.
My lord.
Both the councils you can and find out.
My learned friends, client would be the headmaster anyway. I'm retiring earlier, my lord.
This aspect of the matter which he has said that we have interfered with the orders of the detention order, and the আজি পঠিয়াই পাৰিলে আজি আপলোড কৰাই দিব ডিটেনশ্যনৰ কথাটো আজি পঠিয়াই দিব আজি এতিয়াই পঠিয়াই দিব Thank you.
Applies, Lordship.
Lordship, sorry, Lordship, we overlook one item listed on supplementary list, item 64, connected with item 14 and 15, Lordship. Lordship, Nota may come up on Monday along with item 14 and 15. Thanks, your
We
Lordship.
reached 14 and 15.
Yes, Lordship.
Ah. Oh. Sile. From 64 to 2. List along with WPC number so and so. Item 14. Okay. Item 14. Yes. Anything?
Yes.
What does it say? Towards the end of the 2010 notification, do you have it? No.
Classes 6 to, my lords.
No.
And yes, I have it.
Ma'am. My lord, 2009 RTA came, my lord. Thereafter, my lord, the academic authority, that is NCT, as per section 23, for elementary school 1 to 8, they issued this notification 23/8/2010, where that is mandatory, my lord. And my lord, that I submitted that, my lord, the 2001 NCT regulation. It was superseded by 2014 regulation.
Ah.
This applies to all the schools, my lord. 2014 regulation. And as per this regulation, my lord, B.Ed is an essential requirement, my lord. May I hand over a copy of the 2014 regulation, my lord?
My lord was referring to clause 5, my lord. It says teacher appointed after the date of notification. In the 2010 regulation, my lord.
2010, my lord, in the humble submission applies to, my lord, elementary 1 to 8. The matter pertains to, my lord, high school. And my lord, this 2014.
What is first schedule clause 4?
First schedule, my lord.
Clause 4?
Clause 4. That my qualification, my lord, clause 4. First, my lord, applicability.
No.
Clause 2. What's going on? These regulations shall be applicable for recruitment of teachers and physical education teachers in any recognized school. Any recognized school, my lord, imparting pre-primary, primary, upper primary, secondary or secondary, senior secondary or intermediate school or college imparting senior secondary education. So this will apply to all the schools, my lord. Next, clause 4, qualification for recruitment. Clause 4A, the qualification for recruitment of teachers in any recognized school imparting pre-primary, primary, upper primary, secondary, senior secondary or intermediate school or colleges imparting senior secondary education shall be given in the first and second schedule annexed to this.
You are saying this is only for primary?
This is for all, my lord. This 2014, my lord.
Then?
And 4B, clause 4B. 4A relates to the schedule, my lord, where the qualifications laid down. 4B, for promotion of teachers, the relevant minimum qualification as specified in the first and second schedule are applicable for consideration from one level to the next level. So if a teacher wants to be promoted to the next higher post, then that teacher has to comply with the qualification laid down in this schedule. My lord, the clause 4 of the first schedule. For secondary high school for classes 9 and 10, graduate, postgraduate from recognized university at least 50% marks in either graduate or postgraduate and Bachelor of Education from NCTE. So, my lord, to become eligible for holding the post of a headmaster of a school, the teacher has to obtain this B.Ed degree, my lord. If the teacher does not acquire that, my lord, as per 4B, that teacher is not eligible for consider for promotion, my lord. In the instant case, my lord, the respondent number 4 is not eligible as he has not acquired a B.Ed degree. At her instance, my lord, my promotion order has been interfered with. So, my lord, in my humble submission, my lord, the person who is not at par with me, my lord, only because of the seniority, my lord, the action taken by the respondents in cancelling my promotion order is bad in law, my lord.
So you, who appears for the school? APDCL,
APDCL.
who appears? You appear. What are the rules that you follow in the school?
No codified rule.
As per the affidavit, my lord, this rule, government rule, my lord.
Seniority has been followed, my lord, all along.
No, my lord, no.
For the teacher seniority, that is followed. Accordingly, respondent number 4 was some months senior to the petitioner. So my lord, the fresh promotion order was passed in post hearing.
Without giving any notice?
Okay, sir.
My lord, that stand is at paragraph 9. As
What
per
does it say?
page 68, they said that my promotion has been made in terms of the Assam Senior Secondary Education Government School Service Rules 2020. That clause 14, my lord, section 14. So in the case of my promotion, they have followed this rule, my lord. And this is the period stand, paragraph 9, page 68.
Yes, why do you say the B.Ed will not be
Yes,
necessary?
yes. Well, first of all, my lord, I am in total agreement with my friend that the NCT guidelines provides for B.Ed degree. Now, the question which comes for your lordship's consideration, whether the requirement of B.Ed has been uniformly applied in the state of Assam. Now, my lord, I'm coming to that, my lord. My lord, I have placed a notification of the education department. My lord has a copy, my lord. This already. Please keep it here.
Education department. Hmm? Yes.
Yes. My lord, if my lord peruses the subject for a moment, my lord, it says B.Ed deputation for the session 24-26. Now, if my lord comes to, there are pointers, my lord, this is the last but one. The deputation to undergo B.Ed training shall be given only one time in the career. In case a teacher fails to pass B.Ed examination in one attempt, she will not be considered for deputation for another term. If my lord kindly turns the page, my lord. Postgraduate teacher and graduate teachers of both government and
All Assam Middle English School Teachers Association versus State of Assam.
Yes, yes. Now I'll come to the rules which my learned friend is also referring to, my lords.
Huh?
The rule which my learned friend
In that case, it was held that when the teachers were not given the scope to go for a B.Ed.
That's exactly my argument, my lords. I'm about to place that, my lords. If my lord reads it, my lords, this notification would make it very clear that till today, there are teachers who were appointed before B.Ed was required. They're still serving, my lords. They're still serving, and the government gives them an opportunity to go for deputation. The only reason, my lord, one point, if I may kindly point out, my lords, they are not promoted if they don't have a B.Ed to the post of headmaster, because the 2018 rules specifically provide that to be promoted to the post of headmaster.
So this school of the APDCL,
Yes, yes.
it will have its own universe.
Own universe, my lord. If my lord takes up the 2018 rules, APDCL school is not covered. I'll just read it out just one moment, my lord. The schools which are covered, my lord. Yes. If my lord comes to rule 1.3, my lords, these rule
Page 20.
These rule shall apply to employees appointed for teaching and non-teaching purpose in senior secondary schools, higher secondary schools of Assam, high madrasa, and high schools which have been provincialized under the Assam Secondary Education Provincialized Schools. Now, under these rules, there's a provision for promotion of headmaster. My lord would see the APDCL school does not fall in one of these, any of these categories, my lord. Secondly, my lords, the other rule which has been referred by my learned friend in the affidavit filed by the APDCL, if my lord may kindly take it up for a moment, my lords.
Just a minute.
I'm so sorry. Wait a moment. PDCL has in their affidavit submitted, my lords, that it has been the past practice that always B.Ed was not emphasized upon, my lords. Never, my lords. It was for the first time.
All right, we'll cut it short then. That is the only.
Because my lord, past practice would give rise to legitimate expectation, my lords. Past practice, which has been consistently followed, would
See, field of education,
yes,
past practice for a particular school, if wrong,
yes.
we like this court to say that no, it will be followed or not.
No, my lords. What the point? What I'm trying to
Cannot
make.
be.
Yes.
So we'll cut it very short.
Yes.
He did not have a notice of it.
No.
Notice of his being removed
Yes.
and you being appointed.
Yes.
So, a certain privilege was being taken away from him. He ought to have had notice. He now has notice.
That would amount to a useless formality now,
No,
at least, my
will
lord,
not
where
be, will
the
not
reasons are before him already.
Huh?
Now the reasons are already before him. The APDCL has
Then we'll
filed.
have to, then we'll interfere.
No, in that case, my lord would consider.
You can't have it this way, that way, both ways, sir.
No. I was just my
You
humble
should have-
submission. It's up to my lords, my lord.
Because what
Finally.
we feel is
Yes.
2001 says prior to this, if you were appointed, you would not be required to.
2001 B.Ed was not a requirement, my lord. It was pursuant to 2009
2000
after the RT Act,
in
my lord.
2010.
There is an NCT notification, my lord. B.Ed is the requirement. 2001.
2001. There is a notification.
2001, my lord, after
NCT.
the NCT RT Act, my lord, by virtue of 23, Section 23.
It has been made the top the body to recommend everything for the
Yes.
under the RTE.
RT.
Prior to that, it was not only the
Yes.
RT which was required to be followed.
Yes.
RT was not there.
Yes.
So whatever was NCT
Yes.
was the law.
Yes.
Whatever was granted by the NCT.
2001, the deepest respect, my lord, that point of time, even private schools,
That has the
B.Ed
if you
was not
want
a
to-
requirement
If
for
you
a
want, it will take us some more time, but I'll give you the judgment which says that NCT norms of 2001
Yes.
are mandatory
Yes.
for appointment of teachers, failing which you lose the recognition.
Yes.
The state has to recognize you.
Yes. So,
The non-government educational institutions, they require you to apply for and get a recognition.
33 years, it was established in the year 1986.
Doesn't matter. You must have a recognition, and administrative recognition is what 2006 says.
Yes.
And it has taken into consideration schools which are pre-existing.
Yes.
That administrative recognition has to come, and that requires you to place the rules by which you want to govern your school before it.
Yes. Yes.
Possibly not done, possibly, hopefully done, possibly not done. The recognition
Right.
from the government was necessary. We go into all that, the entire school will suffer.
Yes.
Keep it at that.
Yes.
NCT 2001 required every teacher to be appointed or who was already appointed.
Admitted.
And 2001, as we read it,
Yes.
may lead to a situation, this comma part, this, where is that notification, sir?
My lord, I will find it at page
140.
140. Kumar, you can put it on your page.
Need not acquire, where is it? Need not acquire part? Meanwhile, teachers appointed as per the existing recruitment qualifications subsequent to the issue of these regulations will be required to acquire qualifications as prescribed in the schedule. You are
Yes.
required to obtain it.
Yes, yes, admitted.
NCT 2010 says even for the purposes of promotion,
Yeah.
you require to have the minimum qualification.
Right, right.
Minimum qualification, the B.Ed is necessary.
Yes, yes,
You're continuing as a teacher,
yes,
will not be of any issue because at that point of time, perhaps when you were promoted to the post of assistant headmaster,
yes.
B.Ed was not a necessity.
No, we are promoted together, my lord, both the petitioner and.
No. It was necessary for the headmaster. It was not necessary for the post of assistant headmaster.
Yes, yes. No, the,
If you go through the 18 rules,
yes,
you will find that assistant headmaster does not require a B.Ed
Right.
degree. Therefore, you are given the assistant headmaster.
the point is 18 rule is not even applicable.
May not be,
Yes, yes.
but when the affidavit says that it was under those rules that it was given,
Yes,
and now when the respondent of the APDCL wants to jump back to the
yes.
so-called
Existing rules.
no, practice.
They say existing rules.
When they come to, when they want to jump from a particular rule to the practice, he ought to have had a notice.
That's to that extent. my lord.
Now, if you say it is an empty formality, then 2001 will be applicable. 2010 says that you, for promotion you need it,
Yes.
and therefore for promotion you could not have had it.
Just one submission, my lord. The point which I was trying to put forth, my lord.
Huh?
The point which I was trying to put forth, my lord. First, the law which has been relied by the APDCL while promoting him and later they had resigned. That also clearly says that APDCL school is not. It says, my lord, the rule shall apply to government higher secondary high schools, including
Which one? 2018.
No, the 2020 rules, my lord, in terms of which the
20 rules,
APDCL
it applies to government schools.
government schools.
So 18 rules applies to provincial schools.
I mean, I'm
Done. They had done it on the basis of 18 rules.
20, my lord, rules. They have done it in.
They've done it as per the 20 rules.
20 rules.
Once they do something on 20 rules,
Yes, yes.
if you have a legitimate expectation that natural past practice will come, expectation.
Yes.
He does he not have an expectation that yes, once I'm promoted,
They put to notice if his yes, that's correct, my lord. That is correct, my lord. The notification which
then let him show before the authorities that you are bound to follow 2020 or you are bound to follow the NCT.
yes,
They take a decision.
yes, that's correct. Because, my lord, the guidelines of
Otherwise, 2020 we were not with him
yes,
when he said that it has to be acquired within 3 years.
Yeah.
On a rereading, teachers appointed, already those were
Yes,
appointed, as per the existing recruitment qualifications.
right.
Subsequent to the issue of these regulations will be required to acquire qualification can be one way of reading it,
Yes,
but then we have to miss out one comma.
right.
The comma phrase, from comma to comma, we have to remove from the sentence and it should be a whole sentence. That is grammar. Is it? So when we remove that, meanwhile, teachers appointed as per existing recruitment qualifications will be required to acquire.
Yes. What I was thinking, my lord, perhaps I was not correct, my lord, now. NCT rules provide that B.Ed is a mandatory qualification, right, my lord? The notice, the notification which I have provided, my lord, the State of Assam Education Department, a perusal of that notice my lord would see that there are still teachers who do not have that minimum qualification and they are still serving and the government have given them an opportunity.
That is where we are trying to say
yes,
that All Assam Middle English Teachers Association had filed some case where it was held by this court in a division bench.
Right.
that you did not give them the opportunity, you will not impose it upon them now, and therefore relook into the entire rules. These rules were looked into, and for the assistant headmasters, the qualification of B.Ed was not
Yes.
kept,
Yeah.
whereas for the post of principal, it was kept.
Yes.
Absence of the B.Ed qualification for assistant headmaster was challenged.
Yes. The rule was
The rule
challenged.
was challenged.
The rule was challenged.
The court held that it has to be assistant headmaster also has to have B.Ed. You cannot escape from it.
Yes.
Because it is the requirement of
Exactly. My point was, since persons
No,
without B.Ed.
we leave aside the Assam rules, whatever
Assam.
rules are there.
Yes.
NCT you cannot escape.
No, NCT admitted, yes.
So for NCT, when you admit that the NCT has to have that B.Ed, according to the NCT, you need to have that B.Ed within 3 years from the date of on which this was done.
Yes.
So continuance as a teacher, we do not mind.
Yes.
Although that should not have been as per the 2001.
Yes.
Within 4 years, you did not acquire it, it was supposed.
I was never asked to, none of the
Maybe.
teachers, yes.
So
Because they have to give us the opportunity
It's a
for deputation.
regulation by a authority which is under the Act, NCT Act. You are supposed to know the law.
Yes.
You did not know, they have not interfered, fine, it goes on.
Yes.
But when it comes to a challenge, whether you need the B.Ed or not,
Yes.
either we answer it
Right.
or we let him have everything before the department.
That would be the better course of action.
And you would also have your say.
Yes.
They would take a decision.
And my lords,
You can give you a time
33
frame.
years, everyone was promoted on the basis of
That is another.
and I have
thing.
just 3 months to retire. My
That
lord.
is
I was
another
supposed
question of law where you'd have to be you would have to also address as to whether the prevalent or running practice can overcome
a statutory provision.
that will become difficult again.
Because otherwise it's totally unfair. My lord.
Very unfair.
I was never.
Now let us be fair to you. We had defended that assistant headmaster thing,
Yes.
and he knows perhaps. It was only because 400 to 500 assistant headmasters whose students were going to become assistant headmasters and they would remain teachers. That was the only consideration before the state. And that is why the long-term battle. Otherwise, it would have been, yes, B.Ed is necessary, go for it. The long-term battle was that what happens to those people who have already spent, they have taught these people. And those students have filed the case against the teacher saying that I will be the assistant headmaster, not you, sir.
And in-service teachers cannot voluntarily go and get the B.Ed degree. They have to be deputed from the organization. That was never done. We've never given the opportunity also to go and get the B.Ed degree. 33 years of service.
Mr. Deca, and a counsel.
Since my lord, my friend is admitted that the NCT norms are essential requirements.
My lord may not record that. Admitted it's there.
My lord may decide the matter. My lord, why to send the matter to the school authorities, my lord? Since the NCT regulation is the essential qualification and my promotion to the post of headmaster was never challenged by my friend, my lord. So, my lord,
I was never made a party also when the writ petition was filed. I had to implead myself.
Yes, my lord,
And
because
the
there is
pleadings
no
does
order.
Why did you implead?
I had to
My
implead
lord, there
myself.
is no order promoting him, my lord. Why I should implead in my writ petition, my lord? There is no order in favor of him to promote the post of
Because
headmaster,
the
my lord.
meeting decided, my lords, that I was the senior.
I have challenged so far as my removal is concerned, my lord.
So in that case, that prayer may be granted. my
No,
lords.
only the removal part we can interfere with.
Yes.
We are not deciding anything else.
My lord.
You have made it easy for us. You did not impede him. You did not
My lord, there is
challenge
no,
and apprehended promotion.
my lord, there is no order
Yes,
in his favor, my lord.
Mr. Dekar also. Let us finish some work. Heard Mr. R.M. Dekar and conciliating for the petitioner also heard. Yes, Mr. I Bothakul and conciliating for the respondent number 1, 2, and 3. Mr. P. Mohanta appears for
Four, my
the,
lords.
for the impleaded respondent number 4.
Four, included, wide order dated 14/5/25.
Included respondent number 4, full stop. The grievance in this petition was to the order dated
Page 26, my lord.
26.
How to read petition, my lord.
uh, 632025, whereby the respondent authorities had cancelled the office order dated 17/1/2025 regarding the promotion of the petitioner to the rank of headmaster. Full stop.
And also the respondent 4 as assistant headmaster, same order, same
He
order.
is not challenging it. Yeah, he is not challenging it. The learned, the petitioner was admittedly appointed to the what school?
210992, my lords.
Was admitted to the ASEB High School, Narangi, Guwahati on
210992, the petition.
And the respondent number 4 had been
03
appointed to the same school on
030992.
it is an admitted position that the petitioner holds the B.Ed degree while the respondent number 4 does not hold the B.Ed degree, full stop. By an order dated 17/1/2024 passed by the APDCL, the petitioner was promoted to the rank of headmaster in the usual pay band and grade pay with other allowances as may be admissible as per company's rules, and was posted temporarily and until further orders as headmaster of the ASEB High School, Narangi, Guwahati, APDCL, with effect from the date of taking over charge, full stop, by the same order, but with a different issue number. The respondent number 4 was promoted to the rank of assistant headmaster of the same school on the same terms and conditions. Full stop. The petitioner accordingly joined as the headmaster of the school on the 1st of February 2024. By an order dated 6/3/2025, the promotion of the petitioner to the rank of headmaster and the promotion of the respondent number 4 to the rank of assistant headmaster were cancelled with immediate effect, with the stipulation that no recovery would be made for the excess amount paid to them on account of their promotion, with effect from their date of joining to the date of issuance of this order. On receipt of the aforesaid order, the present petition was filed, and by an order dated 11/3/2025, this court, while issuing notice, had stayed the operation of the order dated 6/3/2025 insofar as it related to the present petitioner till disposal of the writ petition. The respondent APDCL has filed an affidavit in opposition stating that the promotion of the petitioner was initially granted by following, where do you say that? By following the para 9.
Page number.
68.
Towards the end of the paragraph.
Page 60.
Page 68, para 9. madam.
Let me read the entire paragraph. Speaks about past practice.
That the order dated 17/1/2024 was passed in view of the Assam Senior Secondary Education within bracket government schools bracket close service rules 2020, wherein it was stated that the candidate for the post of the headmaster should be a graduate with B.Ed/BT degree from any recognized university and possessing 10 years of teaching experience as graduate teacher for promotion to the post of headmaster. It is the stand of the respondent APDCL that
In para 9 itself, it has been stated, my lord, starting that there is no codified rules for teachers serving in
it
the
has been
schools.
stated that there is no
As a
codified
matter of-
service rule for teachers serving in the schools governed by the respondent APDCL. Full stop.
Therefore, as a matter of practice.
It has further been stated that as a matter of practice, in the past, promotions were being granted on the basis of seniority, and such seniority was again based on the date of joining of the incumbents to the post. Full stop. It is the stand of the respondent APDCL that the petitioner had been promoted under the rules of 2020, bypassing the past practice, and therefore on an application made by the respondent number 4, the decision was revisited and the impugned order dated
17/1.
no,
16.
6/3/2025 had been
16,
passed,
2025.
recalling the promotion of the petitioner as well as the promotion granted to the respondent number. An affidavit in opposition has also been filed by the respondent number 4, stating that the respondent number 4 is senior to the petitioner in service, and although the respondent number 4 does not have the B.Ed degree, possession of the said degree was never a condition precedent for promoting assistant teachers of AACB High School, Narangi. Full stop. The respondent number 4 in her affidavit had also stated that as per a resolution notified on the 14th of October 2024, the respondent APDCL had resolved that the school would continue to follow the existing rules for promotion of teachers.
Page 63, existing rules was clarified, my lord. What is existing rules?
Where is it?
63, my lord, of my affidavit in opposition.
Yes, 63.
Where is page 63?
the last 9/4/2025. Court rule.
By a letter dated 9/4/2025, the APDCL had further clarified that the existing promotion rules followed by APDCL for promoting assistant teacher to assistant headmaster, headmasters is based entirely on seniority, full stop. The promotions are subject to availability of vacancy, reservation roster, and recommendation of the departmental promotion. Mr. Dekar, the learned counsel for the petitioner, has submitted that as per the NCTE regulations, it was incumbent upon the respondent number 4 to have achieved the qualification of B.Ed before she could have been considered for promotion to the post of a headmaster, since by the notification dated
2014, my lord, 12/11/2014.
3rd of September 2001. All teachers who were appointed prior to that notification as per the then existing recruitment qualification, would be required to acquire qualifications as prescribed in the schedule. Instead, the learned counsel has thereafter referred to the notification dated 2014 of the NCTE, dated 2014, dated Kiman 2014.
12/11, my lord.
Dated 12/11/2014, that for promotion of teachers, the relevant minimum qualification as specified in these two schedules would be applicable for consideration from one level to the next level. The learned counsel for the petitioner submitted that the order dated 6/3/2025 had been passed without any notice or opportunity of hearing to the petitioner. Full stop. The learned counsel for the petitioner submitted that this has caused him injustice, since the promotion of the petitioner was being interfered with without any notice of such interference. Full stop. The learned counsel, Mr. Bothakur, the learned counsel appearing for the APDCL, has submitted that the APDCL had in the past promoted the headmasters and the assistant headmasters only on the basis of seniority, without a reference to their having a B.Ed qualification or otherwise. And therefore, in the present case also, seniority or between the two persons being considered ought to play the determining role. Full stop. The learned counsel appearing for the respondent number 4, Mr. P. Mohanto, learned counsel, has submitted that the rules of 2020 do not and cannot apply to the ACB High School, Narangi, Gauhati, since it is not a government school. Full stop. The learned counsel further submits that the mandates of the NCT had not been applied to the state of Assam, at least till the year 2012. Full stop. The learned counsel has further submitted that since the past practice has admittedly been to promote the senior most teacher to the post of assistant headmaster or headmaster, The respondent number 4 had a legitimate expectation to be considered for such promotion, and when the same was not done, comma, on her representation, the APDCL authorities had corrected an error which had occurred in promoting the petitioner to the post of headmaster. The learned counsel submits that correction of an error does not need prior notice to an incumbent who may suffer due to such an order, and therefore issuing notice, therefore the ground of the petitioner regarding the absence of any notice would now be a mere formality. Good stuff. I have heard the learned counsel appearing for the parties, and I have also perused the different documents placed before this court in support of the submissions made. Full stop. It is not in dispute that the petitioner had been promoted to the post of headmaster by the order dated 17/1/2024, and he was also given the benefit of a pay and other allowances as applicable to the rank of headmaster in the school, which he continued to enjoy till 6/3/2025, when the said promotion had been suddenly interfered with. Full stop. The order dated 6/3/2025 does not reflect in any manner the reasons for which the said order had been passed. Full stop. On approach to this court, this court had stayed the operation of the order dated 6/3/2025, thereby meaning that the petitioner has continued to hold the post of the rank of headmaster. Full stop. It is settled law that an order passed to the detriment of the social or an order passed to the detriment of the position that a incumbent holds in service would also have repercussions not only on his service but also on his social standing, and therefore the courts have always insisted upon the tendering of a notice before such a detrimental order is passed. Full stop. In the present case, it is apparent that the order dated 6/3/2025, while on the one hand did not disclose any reasons for passing of the said order, there on the other hand also failed to be preceded and was also not preceded by any notice upon the petitioner regarding the intent of the competent authority to withdraw the promotion to the rank of headmaster. Full stop. The effect of the NCT regulations on the promotion of the effect of the NCT regulations on the prospect of the respondent number 4 being considered for promotion to the next higher post, be it to the rank of assistant headmaster or headmaster, has to be dealt with by the respondent authorities, comma, since it is their stand that the rules of 2020 would not be applicable as the school is not a government school. Full stop. The admitted position being, the admitted position is that there are no codified rules governing the promotions in the APDCL, in the APE, what school do they call
ASCB
it?
High School, my lords.
Huh?
ASCB
ASCB High School,
Narangi.
Narangi. Full stop. It is therefore left open to the APDCL authority. No, to land. It is now open to Katidiok. Next. Be that as it may, this court is of the considered opinion that the petitioner in the present case deserved a notice prior to the passing of the order dated 6/3/2025. Full stop. This is not to say that the competent authority would not be in a position to pass such an order, but the requirement of giving a notice to the petitioner, affording him an opportunity to, no, giving a notice to the petitioner, comma, explaining the grounds on which his promotion is sought to be withdrawn, comma, had to be served upon him, giving him an opportunity to counter such proposal, full stop. Accordingly, the order dated 6/3/2025 passed by the APDCL insofar as it relates to the withdrawal of the rank of headmaster from the petitioner is hereby interfered with and set aside, full stop. The respondent authorities, comma, in case they want to withdraw the promotion granted to the petitioner, comma, shall issue an appropriate notice to the petitioner, giving him an adequate opportunity of making a representation and of being heard in the matter before such withdrawal is effected to, full stop. The respondent number 4 shall also be informed about such notice, comma, if any, served upon the petitioner, and shall also be granted an opportunity to be heard before the decision, before any decision is arrived at by the competent authority, full stop. This petition accordingly disposed of. No, well, prior to that, you write, since the matter relates to the holding of the post of headmaster of a particular school, comma, the authorities are expected to take a decision on the matter within a period of 6 weeks from today, comma, in case they want to proceed. Full stop. The till such time, comma, the status quo as on today shall be maintained.
Very grateful, deeply grateful.
Thank you. Give it a video credit. Item? Yes.
Lordship, the instruction, I'm not receiving instruction, but AZ Lordship, he sought some instructions.
No, it was sought from DC office.
Accountant General,
Yes, yes.
what will he say? Yes, Accountant General, why are you not paying?
No, they are paying, and a grievance is with regard to the deputy commissioner, because
We
the,
wanted that to come from Mr. Talukdar. That sentence we wanted from Mr. Talukdar.
Yes.
Yes,
Now, Lordship, I have to take the instruction.
4 o'clock list.
Lordship,
List.
Lordship, can it be fixed on tomorrow or day after tomorrow, Lordship? Day after tomorrow is more feasible, Lordship.
tomorrow, for me, day after tomorrow,
They are
little
more-
difficult.
Then Monday, Lordship, it will be
Otherwise tomorrow.
feasible, Lordship. Deputy Commissioner Nagaon, I will sort for
You are receiving the regular pension.
Yes.
Yes,
The regular pension you are receiving.
only area, no?
Yes.
Yes, area, I will take
Huh?
only the area.
Only
The area
from
it on,
97 to
Yes,
2004.
Yes, Lordship, yes.
What do you
Yes,
say in Assamese? Konstapon.
Yes,
It will be well enough to give Konstapon to the lady.
Yes.
Realize?
Yes, Lordship, yes.
Huh?
We have the responsibility, Lordship.
That is one part. And
Yes.
with the manner in which every price is going up,
Lordship.
sooner the better.
No, pension.
Otherwise, it will become what? It will become nothing.
Lordship. Monday, Lordship.
Monday. At the request of Mr. So-and-so, Learned Counsel, appearing for the
Lordship,
Which
I am
department?
1 and 3, Lordship.
for the respondent number 1 and 3. List this matter again on Monday. What is the date?
25.
25th of May 2026. Full stop. The adjournment is granted only on the assurance of
Lordship, I will-
Mr. So-and-so, Learned
Yes.
Counsel, appearing for the respondent number so-and-so,
One.
so-and-so,
Yes, 1 and 3.
that appropriate instructions will be placed before this court on the next date fixed regarding the mode and manner and the time frame that would be required to make the arrear payment to the petitioner. Full stop.
Lordship.
Deeply.
Yes, ma'am.
Lordship, apologies, I could not take it in the first round.
No difficulty, ma'am. Tell us.
Lordship, this is a petition for regularization. The petitioner was appointed in 2007 in the Borkola ICDS project. It's an integrated child development services in Kachar. It was inaugurated in July 2007. The place where the office was belonged to the petitioner's brother. They had nobody, so they inducted me. There is no official record of appointment letter,
Okay.
which is usually the case always. Lordship, thereafter, we continued. Even the affidavit don't dispute that we have continued. There was an advertisement in 2014. I applied, page 24.
Okay.
I applied, my application was forwarded by respondent number 4 to respondent number 3, which is at page 25. Page 24 is my application. While I was working, page 25, it was forwarded. I made representation, which is page 26. Thereafter, at page 28 in 2022, I applied again. So I have been continuing, and I've been saying since inception. And then page 30 and 31 are important because they forward. 30, respondent number 4 forwards to respondent number 2.
Direct.
Application, which is on page 28. And 23, they again forward. March 23. In the meanwhile, from what we discover now, is that in May 2023, they hold
an advertisement and they appoint somebody regular. Now, I could not apply in that because I had retired. No, sorry, my age limit, I crossed the age limit.
Okay.
So the issue now is I still work. I'm still working. And there are certificates to that effect. I've annexed them in my affidavit of 2026 by a respondent to the director. Lordship may see my affidavit. Yes, Lordship may see my affidavit from page 47 to 53.
Were you paid anything in the meantime?
Honorarium, nothing. Which itself is in the teeth of the law. I mean, this is what is exploitative enslavement, Your Lordship. And it's unfortunate. So there is no dispute that they have been availing my service for the last 2007 to now is almost 20 years. So they need my service. They've not left me. I have, on several instances, when the advertisement came up, I applied, that didn't go through.
They say in this affidavit that this project was operationalized in 2023.
No, Lordship, in July 2007. Lordship may see page 47. The 2009 certificate, 48 is the certificate, type copy is
Wait, page 29.
57. 48 is the typed.
Page 40, this is.
47 annexed to.
No, we have seen the certificates.
Yeah, so in
2021.
2009, it says is working in the Borkola ISD project non-officially as a grade 4. This is Child Development Project Officer. So there is no dispute that there is a project going on since 2007 and I've been working. And the last page 53 is of 2026. This is certified so-and-so that the petitioner is working temporarily in Borkola ISD on a voluntary basis from time of inception till date. And even in the affidavit, they say he has been working. There is no dispute. They're not disputing that he is not working, even in their affidavit. They say that we've done a parallel. Paragraph 4 of their affidavit.
Yes, when you are admitting that you are utilizing his services.
No, Lordship, kindly say paragraphs 4, Lordship.
Huh?
Paragraph 4 in my affidavit,
we-
39. That the deponent begs to state that what happened, Lordship, is a building that was this ICDS project. The office used on rent is owned by the elder brother of the petitioner, Lordship. That is the cause, Lordship. Because he came sometime doing something, Lordship. This owner completely here. There is no specific. There is no contention specifically mentioned that he is regularly work in our ICTS project.
Your certificate says so.
The certificates are different, Lordship. No time is given, Lordship.
No time?
No, the period is not given in the certificate.
From the time of inception of the project.
No. This certificate, can you say annexure 1?
No.
This is to certify that so and so is working in the ICDS project non-official in the grade 4 from the time of inception of the project. That was, it is non-official, Lordship. He was not engaged, Lordship. It's not the engagement letter. Because due to that house was the owner of that house where the ICDS project was functioning is owned by the elder brother of the petitioner, Lordship. That's why, Lordship, this is not the official certificate. This is
It is not the official.
Yes, Lordship,
certificate.
this
The use
was
of
not-
the seal.
no,
The use
no,
of the seal does not say.
although,
it is an
this is not the official engagement.
engagement or engagement letter
No,
is
but
not there.
Lordship, on the basis of this, how can we regularize the person?
Huh? Regularizing you cannot. What can you do? Tell us.
See, Lordship, I have to take the proper.
When you admit that this man has been working and you and your officers allowed him to work.
No, that particular.
And this forwarding.
The forwarding is, Lordship, that it was forwarded. His application was forwarded, Lordship.
Why is it sent to the officer in charge? This page 32, why is it sent to the officer in charge of the police station?
Let's see. Page 32.
32 is the staff pattern, I think.
But it has been issued to the officer in charge.
This is
Yes.
this we cited to say in 2016 he was in the staff pattern, Your Lordship.
No.
I know,
It
this
is
is-
in response to a
Yes.
letter from the DSB,
Yes.
security branch. What do you call it? Not security branch. This DSB branch, they give this. On the passports also, it is the DSB branch, arms ammunition license, DSB branch. Yes. What about page 32?
Yes, Lordship. Lordship, Lordship, here in this case, Lordship, name of the employees not given in the list of the employees, Lordship. But, Lordship, it is a remark column, it is stated that he is working temporarily as grade 4 on voluntarily basis.
A man
As
would-
agreed by the SDP, Lordship, it is also categorically stated, as agreed by the SDPO, Borkola so memo number so mobile number so. It means, Lordship, as agreed by the one person, Lordship, that is the SDPO of that time.
So your SDPO engaged him.
It's a personal language, Lordship.
Huh? No, this has to stop somewhere someday.
Yes, Lordship.
We know our limits, whether we can order for regularization or not.
But
this has to stop someday.
no, now, Lordship, now what is the position I have to
It
take?
continues. That is the position.
No, that
Continues
is not,
as of-
that is not given.
as after filing of the writ petition, he
No,
continues.
no, but that is not shown in my affidavit, Lordship, as the PO's affidavit.
Need not be. Do you dispute page 36? Do you dispute page 36?
Lordship, the affidavit from the director is yet to be filed, Lordship, because director, grade 4 employees, the CDPO cannot engage.
Who can engage?
Yes, it is the director, Lordship.
Since when?
Lordship,
Since when?
Lordship, that I have to take the
And
instruction. Lordship.
who was the authority empowered to appoint someone in the year 2007? 2007.
Lordship, Lordship, the CDPO may not be, Lordship. The district officer may be, Lordship, but
No, no.
CDPO, I don't think.
No, at least till the year 2019, we have seen appointment orders by the CDPO.
CDPO. Lordship, I have to
And
take the
not of
instruction.
grade 4 of
No, but
posts a little higher than that.
no, grade 4
A
may
little
not
higher
be,
than
Lordship. Grade 4 may not be, Lordship.
that. Grade 4 will be
Because
director.
Anganwadi worker may be, Lordship.
Who appoints? CDPO.
Now the director, Lordship.
Now director, but
Yes.
at 2007, who appointed?
Maybe the CDPO, Lordship.
So the
But
CDPO
grade
agreed
4,
to
Lordship,
appoint
grade 4 is higher than the Anganwadi
this
helper
is
or
the-
worker, Lordship.
See, unless you say this is an illegal appointment and you bring before us the CDPO,
Lordship, that,
and all these CDPOs who allowed this work to continue.
Lordship, that may happen. Now,
Is it slavery?
no, Lordship.
Huh?
So what is
The
the
way of hope.
No, but his house, the particular house.
You take his house,
No. It
You
is
take
by
his
rent,
job.
Lordship. No, by
you
rent,
take
Lordship.
his time,
No.
his life, and then you say,
With that
"Oh,
advantage, Lordship.
I am not with the CDPO, but let me tell you, the very person who has signed this affidavit must have had a cup of tea when he went on a visit from this very man,
No, but
appreciating his promptness in bringing that cup of tea to the meeting.
maybe, Lordship. But take a call from the director, Lordship. I will submit one affidavit on behalf
This
of
is
the
of
director.
2023.
Yes, Lordship, but I have to submit an affidavit, Lordship,
Okay.
short affidavit. 2 weeks time is required.
Identifying the
Yes, Lordship. All this point, Lordship.
identifying the appointing authority
Lordship.
for the post of grade 4 in the ICDS projects,
project,
number 1.
In the year of 2007, Lordship. Yes, Lordship.
Bring it on record.
Lordship.
If CDPO was the appointing authority, would it lie in your mouth to now say that yes, he did not follow due procedure of law after taking 20 years of service?
But the service, regarding service also,
Mhm.
Lordship,
You have
this
taken-
affidavit.
Every CDPO has given that certificate. Yes, working.
It's now.
Okay, show me one person who would work knowing that I am not being paid anything.
Let's see. Lordship, I have to take a call from the director.
Huh? Heard. Ms. P. Goswami, learned counsel is paying for the petition also. Learned. Ms. G. Goswami, learned senior
JK
counsel assisted by for the petitioner. The learned counsel appearing for the respondent department has submitted that the affidavit in opposition by the director is yet to be filed, although the affidavit in opposition has been filed by the CDPO concerned. Full stop. Granting time to the Director of Social Welfare Assam to file the affidavit. Now, is this matter again on?
Lordship, after 2 weeks, Lordship, May. Can it be on 8th of June?
8th of June,
Yes.
2026, full stop. The affidavit of the director should the affidavit of the director shall also inform the court the concerned appointing authority for grade 4 posts in the year 2007 in the ICDS projects.
Lordship will keep it part-heard.
We don't know what bench we would hold.
Therefore, Lordship will keep it part-heard. You've heard your Lordship. I've finished.
Without the affidavit, can I keep it part-heard? I have not seen the affidavit of the director. Let us hope we come upon it. Yes, next.
We have resolved also.
Ah.
Like 2-3 times, my lord, we have taken time for affidavit, my lord, may kindly allow 1 week time as a last chance.
Well, what is the subject matter?
Regarding provincialization.
My lord, here in fact is that, my lord,
Provincialization.
Provin-
Without the affidavit, nothing is happening.
My lord.
My lord.
Already I have received.
On the Mr. Swenson and counsel appears for the petitioner.
Last opportunity.
Huh?
As last opportunity, because he himself is saying that he is taking
Okay,
it.
I
Why do you stress on it? Let him have some breathing space. Allowing the respondent department to file their affidavit in the matter. Place this matter again on How much time do you want?
What, 2 weeks, madam?
Weeks. This is matter again on 2 weeks also data side. Yeah. 19th of June.
My lord.
19th of June.
My lord.
2023. You are appearing for? Respondent Mr. Anali appears for respondent number 7.
A Goswami for 6, sir. Respondent 6.
Have we heard this matter before? Did it come up before us on some earlier occasion?
Yes, my lord, perhaps
Yes.
for a single occasion.
Mr. Talukdar assures that this is this would be the last accommodation sought for to file the affidavit. Yes. Yes.
Good luck.
Next it is. All right. Yes, sir.
The matter relates to termination of service, Lordship.
On what grounds?
Lordship, termination of service, Lordship.
Would it require some hearing? We'll then
Lordship.
take it up in a
Lord.
on a fixed hearing day.
Lordship, can it be on, Lordship, 16th of June, Lordship? Hearing the
16. List. Pleadings are complete. Anything more to be
Pleadings
done?
are completed.
So-
Should
so
we
it's
come off after 2 weeks?
After 2 weeks, choose a date.
Hmm?
Choose a date.
16th June.
Heard the learned counsel appearing for the parties. They submitted that the pleadings in the matter are complete. Matter relates to a disciplinary proceeding. Instructed. List the matter again on
16th of June, Lordship.
16th of June,
16th.
2026 for admission hearing. Full stop. Respondents would keep the records of the disciplinary proceeding available on the next date fixed.
Oblige, your Lordship.
Obliged.
Sorry, my lord, same prayer, my lord, for affidavit, my lord.
Yes, that earlier prayer you had written, na? Mr. Talukdar assures that it is the last accommodation being sought for. Huh? He's giving an assurance. This is
No.
the last accommodation.
My lord. Obliges. Moved it.
একেই দি দিওঁ আগৰটোৰ লগত এইটো নবি আগত না তাৰ আগতো Yes, madam.
Lordship, this matter pertains to pension. Notice has been issued on 25/6/25 and affidavit has not been filed yet. Give some time, maybe not file our affidavit.
From 2025, how much more time do you want?
Lordship, instruction has not received.
Instruction not received, so we can allow it. Who is the opposite party?
Indian law.
Pension.
Yes, sir.
Where is your discharge order? No, 48 entries. Yes, by when will you file it, madam?
3 weeks. Fixed date may be given.
Your name?
A Bora.
The council appearing for the petitioner has submitted that although notices were issued in the year 2025 from other respondents are yet to file their response to the petition. Your name?
M Bora, Lordship, on behalf of SP Chaudhary. For all the
Behalf of
respondents.
Mr. SP Chaudhary. For the respondents has submitted that 3 weeks accommodation will be required to file the response full stop. The matter relates to the discharge of the petitioner from service, where the petitioner has paid for grant of pensionary benefits full stop. List the matter again after 3 weeks on June last of 25th of June 25th we had a hearing day 24th of June. Summer vacation line to 15th of June 2026. Yes? 3 weeks. 15th of June 2026. By which time the respondents shall file their affidavits.
Similarly, in item 23 as well, affidavit was.
I already sent it for vetting, my lord.
And you sent it for vetting 2 months ago.
For that. In between, I had some personal difficulties.
No, no, no. We listed on the same day. On,
Same day.
what did you say, 15th?
15 June, that will.
Miss so-and-so, the same name will be there. Mr. G. Pegu, done at CGC, representing the Union of India. Mr. Pegu assures that the affidavit in response to the petition will be filed within a period of 2 weeks from today. Accordingly, list the matter again on the 15th of June, 2026, along with the affidavit proposed to be filed.
Yeah, obliged.
Yes.
Your Lordship. But in this matter, Commissioner BP will only appear. He is unwell, Your Lordship. He was there in court, but he had to leave.
Pleadings are complete.
Yes, Your Lordship.
Any urgency in the matter?
Sir, the petitioner is about to retire on August in this year.
Suspension.
Yes, Your Lordship. Next date, any date.
Huh?
Next date, a date will be fixed, Your Lordship.
So next date may be given. Very good. At the request of the learned counsel for the petitioner, list this matter again on the 17th of June.
Yes, Your Lordship.
17th of June.
Obliged. Wait, please, Your Lordship.
Lordship, before my learned friends start, Lordship, so far in my office note of my file, Lordship, it appears that no extra copy furnished to me, Lordship. Although notice issued, I took the notice, Lordship, but extra copy is not submitted, Lordship.
What have you challenged? You are discharged from service.
Discharge from
Serve the extra copies.
The PSC matter, Your Lordship.
Serve the copies.
I will take the instruction from
You will
the
have to
parties,
take
Lordship.
it.
Yes.
He will have to take instructions. Right? Mr. Goswami, learned additional senior government advocate, has submitted that requisite numbers of extra copies of the petition have not been served upon him. He is not available with him, full stop. The learned counsel for the petition has agreed to serve extra copies to service on the learned counsel for the state respondents within a period of 2 days from today. List the matter again on, yes, tell us when.
Lordship, 3 weeks time is required, Lordship.
Already discharged.
Already discharged. Interim order will be considered on the next date, Your Lordship. There is also notice on interim order.
Okay. List the matter again on the 8th of June.
Can it be on June 12 or 15? Any
15th of June 2026, full stop. Notice on the interim prayer had already been issued, comma, the same will be considered on the next date.
Obliged.
May please, Your Honor. This concerns the discharge of an ACS officer on 20/08/2025. This honorable court passed the stay order.
None appears. What to do?
And my lord, since long they have been taking time to file the affidavit.
But the interim, what does it say? Your services are protected.
Having heard and upon consideration, since
So
meanwhile till the next returnable date, the impugned notification dated 21/7/25 shall not be given effect.
so it is still you are in service now.
Yes, no, Lordship. I am out, but the discharge order has been stayed.
Mr. Goswami, who is required to appear in this matter?
Lordship, senior government.
If not the senior, then at least the additional senior will do.
Yes, Lordship.
Tell us.
But Lordship, kindly accommodate some time, Lordship.
Find out, are they filing an affidavit, and if so,
No,
by
we
when?
will file, Lordship.
Then Lordship will give this the last opportunity.
No, Lordship, last support.
That is why we are asking you,
The-
find out from the concerned counsel who's handling the file as to when they would file the affidavit.
Lordship, I am taking the risk.
Then we'll fix it again on, before the vacations, we'll fix it on 22nd of June.
22nd. Lordship, today is 22nd. Can it be on?
Today is 20
Yes, Lordship. Can it be on 10 or 11
of
June?
very well,
No, July.
very well.
No. Lordship, I will take
Yes, yes.
on. Lordship, 22nd of June, Lordship. I will file.
You wanted it early. We were giving you 22nd. You said no.
Lordship.
I want it on 10th.
Lordship.
10th.
No, 10, Lordship, I will call the instruction. Lordship. I have to take some time for preparation of my affidavit, Lordship.
Heard Ms. P. Chaudhary, learned senior counsel, assisted by,
Imsen Kala.
for the petitioner, also heard Mr. J.K. Goswami, learned counsel appearing for the, learned additional senior government advocate appearing for the respondents.
Lordship.
Mr. Goswami has assured the court that the affidavit in opposition will be filed within a period of 3 weeks from today, full stop. List the matter again on 22nd of June 2026, allowing the respondents to file their response to the petition.
Interim to continue.
The interim order passed earlier continues.
Much obliged.
So, before going into the facts of the case, Lordship, may come to page 48.
48.
For page 48, I'm relying on your order, Lordship, where once your Lordship, page 48, or whether you Lordship like to take out.
You are relying on this,
Yes, yes,
where we had succeeded.
yes.
So placing a reliance would also be difficult now. Is it the same person?
Not same person, Lordship. Person is defined.
What is the matter?
Lordship, although I have served for long 40 years, Lordship, my service is not recognized for pension, Lordship, under 69. Now, in this judgment, that was clarified, Lordship. The authority have to, Lordship, recognize the period.
Now let us tell you one thing.
Lordship.
Search the Wakalatnama. Perhaps it is not us.
Lordship.
We seldom forget a running matter. The name is similar. Not us.
Lordship.
At least not an Anganwadi. We never fought for a regularization. Yes. Yes, tell us.
Yes. Now, initially, she was appointed as Anganwadi worker in 85. So in 2000, Lordship, she was called for interview for promotion to the post of supervisor. So ultimately, in 2011, she was promoted, but on contractual basis in a fixed pay. That Lordship will find at page 30.
You have to file an affidavit. Have they
Yes,
filed
they
an
have not
affidavit? Without an
responded.
affidavit, can we hear it completely?
They have not filed any.
Or at best, we can say that the department will consider whether the matter is similar to the one at page 47. And then they will come to a decision.
Yes,
What do you want?
Yes, yes. Second one, Lordship.
Yes.
Lordship, instructions are awaited, so you kindly can.
No, already, yes, already there. You
But
will-
Mr. A. Kalan, counsel appearing for the petitioner. Should we write assisted by as well? Also heard, yes, madam?
B. Shohei, Lordship.
Appearing for?
Mr. J. Chutia. KAAC.
Huh?
KAAC on behalf of Mr. J. Chutia.
The,
Respondent
appearing
number.
for the
245.
AAACs. AAAC
2, 3, 4, and 5.
on behalf of Mr. J. Sukiya.
I'm thus appearing on behalf of SK for respondent number 7.
You? But you have to give your name. You got the name or you want it in writing? Writing in writing. The learned counsel for the petitioner has submitted that the petitioner had been engaged as
Anganwadi worker in 1985.
Anganwadi worker
In 19, at Lordship. Lordship, can you annex the 1 page 20. ICDS project of Howrah Ghat, Karbi Anglong. Howrah Ghat.
Annexure 1.
Annexure 1. This was the interview letter. They about after I join also there.
Had what did they say? The learned counsel for the
CDP or
petitioner
Howrah
has
Ghat?
submitted that the petitioner had joined the Howrah Ghat ICDS project
Yes.
from Akarbi Anglong after in the year
1985.
1985 after undergoing a process of interview.
Yeah.
Full stop.
Then thereafter in page
When-
27.
Then in the page
Page 27 on 11/1/2000, I was called for interview
the
for
petitioner was thereafter called for participating in the interview being conducted for the post of supervisor
supervisor.
in the same ICDS project
Yes.
by an office order dated 11/1/2020 and
No,
there
2000.
11/1/2000 and for full stop. Don't know what happened.
Thereafter, lots of steps were not taken. Then ultimately I approached this.
By the order dated 14/6/2011, the petitioner was temporarily engaged on contractual basis as supervisor
Against the
against
sanction.
the sanctioned vacant post in the Lumbajong ICDS project, Manja. You will find it at page 52. I've underlined it, huh?
Then I retired, Lordship.
Full stop. The petitioner thereafter retired
31st of 10/2025.
on 31/10/2025.
Yes.
Full stop.
Then I submitted a representation for my service benefit.
The petitioner thereafter submitted several representations for grant of service benefits, and on the same not being made available to her, she has approached this court by filing this writ petition. Full stop. The learned counsel for the petitioner has submitted that the case of the petitioner would be covered by the order dated 23/3/2022 passed in WPC number 1999 of 2022, wherein this court had under with regard to a similarly situated candidate directed the respondent authorities to prepare a pension proposal by taking into account the service rendered by the petitioner in the said case as an Anganwadi worker and thereafter submit the papers to the Office of the Accountant General for final approval and payment of pension. If the petitioner therein had already completed 20 years of service by taking into account the period of service rendered as Anganwadi worker as qualifying service, full stop. The learned counsel for the petitioner has submitted that the respondent authorities, that the petitioner would be that the grievance of the petitioner for the present can be redressed by directing the respondent authorities to take into account the service record of the petitioner
Yes.
and thereafter evaluate whether the petitioner is similarly situated as the petitioner in WPC 199 of 2022 and thereafter come to a conclusion regarding the entitlement of the petitioner to the pensionary benefits, full stop. He praised that the petitioner, that the respondent may be given a time frame within which the aforesaid decision may be taken and the petitioner may be granted the liberty to approach this court again if the decision goes against her, full stop.
But you didn't know your time frame is within 4 months or 5 months.
The learned counsel for the respondents have not objected to the aforesaid proposal made by the learned counsel for the petitioner. Accordingly, this writ petition is disposed of, directing the respondent authorities to take into account the service records of the petitioner and if required, service record of the petitioner, by requiring the petitioner to submit all necessary details regarding her service before the project, what do you call it? The project officer ICDS.
Hauraghat. No,
Lumbajong ICDS
sorry.
project, Manja, who shall thereafter take immediate steps to forward the service records to the appropriate authority to decide the entitlement of the petitioner to the pensionary benefits, by keeping in view the submission of the petitioner that she is similarly situated as the petitioner in WPC number
I'm sorry
199
to
of
interfere, Lordship.
2022.
Page 46, already authority Lordship has taken note of that, the service. Annex of 14, page
Full stop.
46.
The authorities shall also take into account the letter dated 18th of November 2025 issued by the CDPO Lumbajang ICDS project Manja Karbi Anglong to the program officer divisional ICDS cell, DIFU, whereby it has been stated that the petitioner had been serving as supervisor since 13/6/2011 and was regularized on 5/2/2021. Stop. The entire process of consideration of the case of the petitioner shall be completed within a period of 4 months from the date of receipt of a certified copy of this order. Which the petitioner would be at liberty to approach this court again in the event the decision is not the decision is not in her favor, full stop. The petition accordingly disposed of. No order as to post.
Deployed.
Am I going too fast? Am I speaking too fast? Recording it? Oh, okay. Yes, sir.
Lordship, in this case, I have received one affidavit in opposition filed by the Health Department, Lordship, wherein, Lordship, it is stated that service book has been forwarded to the Accountant General Office, Lordship. So 7 days time, Lordship, I want, Lordship.
My lord, only one thing, my lord, in the whatever they have filed, my lord, the service book, I find it difficult, my lord, to understand, my lord, at page 46, my lord. My entitlements, maybe some correction is required, my lord, that I'm pointing out, my lord.
That is the usual process. It goes wrong, it comes back for correction, it goes wrong, it comes back.
My lord, can we see the
Correction.
page 46 and except of their affidavit?
Tell us what is wrong.
My lord, my date of joining is 4th February to 1993. Then promotion nil, length of services 30 years, such and such, number of promotion, these 2 benefit I got. Completion of 30 years of service on 4/2/2023. Next, they have said the due date of MACPS is 1/1/24. It should be the day of completion when I have completed 30 years, my lord. Career advancement scheme says, my lord, I should get increment at 10 years, 20 years, and 30 years. So, my lord, if it is And I retired in March
See,
24.
let us have it this way. We start interfering with on this ground on this now. Your entire process gets held up. I will record your submission that there are some anomalies, possibly to your detriment, in the once we record that, they will hold up everything. If you allow this to proceed, file another writ petition challenging whatever is written here.
No, my lord. My,
Get them connected, get your order.
my lord, my promotion, my pension is to be
So
recalculated.
what do you suggest today? Your suggestion, tell us. We will say that this order, this annexure 2, page 46 is not correct according to you, and therefore the respondent should look into the
Yes, my
matter,
lord. They should correct.
correct it and then send it.
My lord, I am getting pension right now, but that has to be recalculated. My lord, if it is wrong, my lord, then my pension again it will be.
Have you got your pension?
Yes, I
account?
am getting it, my lord.
She's
Provisional.
I am getting.
She's getting
No,
final
regular
pension.
pension only.
Then what do you want?
Only MACP benefit, Lordship.
MACPC benefit. They have not given me that time scale benefit. So I pray, my lord, that may be given and my.
You are
pension
not
will be-
given any one of them, that first,
Not-
second,
They
third,
gave.
the third one.
Third one they have not given.
Who has issued this?
My lord, this is issued by Chief Medical and Health Officer Borpeta, my lord, under whom I was working.
Who represents? Madam, you represent?
Yes, Lord.
Day after tomorrow? We'll have this day after tomorrow. Have your instructions on page 46.
Day after tomorrow, my lord, that's the reason.
No, page number 47, Lordship.
What is it?
This is not clarified.
You are not getting what is being said. Please come to page 46. Your page 46?
Yes, Lordship.
Date of joining service? 1993.
1993.
Please add 30 years to it.
Yes,
When will it be?
it will be 23.
2023.
Yes, yes.
Now look at the
24 to 23.
due date of MACP 112024. Yes,
Yes, Lordship.
this man has sent a wrong calculation. Yes,
Yes, Lordship.
take your instructions on Friday
Lordship.
as to whether he's sending the corrected document or not.
Lordship.
Otherwise, rank of additional chief medical and health officer 30 years from 1993 should be calculable to him.
Lordship. Maybe it is typing mistake also.
So have it corrected. We'll have it on Friday at the
Lord.
request of Ms. Bora, learned counsel, appearing for the respondent number
Health Department, Lordship.
for the health department, comma, to have instructions on the correct date of, on the correct due date of MACP of the petitioner.
23 over
Place this matter again on
22nd.
22nd of May 2022.
Lordship, for annexure 347, Lordship, I want some time, Lordship, because they have forwarded us the service.
We are just now listing it on February to have this 2023 corrected.
Lordship.
Otherwise, you will process the wrong file. If they admit to the mistake, we'll record it in an order. They can give you the order copy.
Then
You will correct it properly.
Yes.
Lordship.
Right? Because there may be some reason he might have undergone a disciplinary proceeding. So many reasons why it is 2024. You don't know.
Oh, my lord, their service book itself says my career is good, my lord. They have submitted it.
Yes, it is.
You will not go
anyways,
into an inspection of
Yeah.
service.
I'm deeply obliged.
Yes.
May I please, Worship? Worship, the petitioners are the Anganwadi workers, Worship.
Hmm.
And it is their Anganwadi workers, Worship. and it is their primary job, Lordships. And in addition to that, Lordship, they have been engaged as BLO, Lordship. Both level
Top
of
level of, booth
both,
level
both
officer.
level of
Ah,
Lordship. Now, Lordship,
booth
have
level
been-
officer for what?
Lordship,
To do what?
to Lordship to enlist
Election
in the
duty.
voter list, Lordship.
Okay.
Lordship, it is the periodical job, Your Lordship.
Ah,
Now, Lordship, they have been dropped, Lordship.
they have been?
Dropped from BLO.
Ah,
Lordship, that is page 42,
ah,
their notification, Lordship.
ah.
Now, Lordship, that we have filed representation, Lordship, and that has not been considered, Lordship. Our prayer is that, Lordship, that maybe the petitioners may be allowed to continue as a BLO, Lordship, along with, Lordship, their primary job, Lordship.
You are earning some money, let someone else also earn.
Lordship, that
You
is
have
the-
a job.
Lordship.
Let someone also have a part-time job at least.
Lordship, those who have been engaged, Lordship, they have also their primary job, Lordship. We have been
Yes, sir,
removed,
why are they being released? Any,
Lordship, they have not.
no affidavit?
We have filed an affidavit, Lordship.
They have filed affidavit, you have filed your reply.
Lordship.
What is the stand?
Our state is paragraph 2, my lord, and 3. Paragraph 2, my lord, the deponent begs to state that Secretary to the Government of India, Ministry of Women and Child Development, dated 5/11/2019, requested the state governments to issue strict instruction to all the concerned departments and officers not to deploy Anganwadi workers for any other duty except Anganwadi services. Poshan Abhijan scheme for adolescent girls, Pradhan Mantri Matu Bandhana Yojana, and other women and child-related workers' activities.
Prerogative of the employer, sir.
So they are
Lordship,
debarred, my lord. They
It
are
is the
working.
prerogative of the employer to say where you should work.
Yes.
Lordship, the grievance, Lordship, in the Morigaon, Lordship, it has been done this way, Lordship.
What
But
is her-
nearby district, Nagaon, Lordship, the Anganwadi
In
workers,
Morigaon, the birth rate was smaller in a particular year, therefore they have lesser number of children to take care of, and therefore they can go out.
They
In
cannot
your
leave the
district, the
center.
population is high, you have more number of children to take care of. You cannot be released. Are these questions that we should answer or we should ask? No.
no,
It is the employer's prerogative what they want to do. Close it today or
Lordship,
some ICU?
no, Lordship, it may close.
Close.
No.
Mr.
And Hawkins.
and Hoagland Council appearing for the petitioner also heard Mr. J. Chutial and Council T.C. Chutial and Council I got to point it, I guess. Mr. T.C. Chutial and Senior Counsel assisted by appearing for respondent number
Number, my lord,
1 to
2,
5. 1 to 5, sir?
1, 2, 3, 4, and 5.
5.
6 also, my lord.
And
Not
6.
6.
You are appearing
Yes.
for
Which is-
your name?
And the cast on behalf of RDB.
On behalf of? RDB. Ah, okay.
But it will district.
The grievance raised in the writ petition by the petitioners was with regard to the dropping of their names from the list of what do you call it?
Both level officer.
Booth level officers
Lordship.
by the district commissioner, Morigaon, Assam. Most of the petitioners claim to be Anganwadi workers working in their respective Anganwadi centers, and they were earlier engaged as BLOs
BLO.
by the Election Commission of India, Election Commission Assam, to work as BLO. However, by the order, by the notification dated can you give us the date, sir?
3/7/25.
Huh?
3/7.
3/7/2025,
Lordship.
the petitioners were not continued as BLO. The Council for the petitioner has submitted that their non-engagement as the BLO has had a financial implication on their earning. And since the work of a BLO can be carried out after they finish their daily duties of the Anganwadi workers, comma, a direction may be issued to the respondents to consider to continue to engage the petitioners as BLOs. Full stop. The respondents have filed an affidavit in opposition, comma, placing reliance on which, comma, Mr. Sutia, the learned senior counsel, has submitted that the Government of India, Ministry of Women and Child Development, by their DO dated 5/11/2019, has requested the state governments to issue strict instructions not to deploy Anganwadi workers for any duty except Anganwadi services, comma, Poshan Abhiyan, comma, scheme for adolescent girl, comma, Pradhan Mantri Matru Vandana Yojana, and other woman and child related work and activities. He accordingly submits that it would not be feasible for the it would not be feasible to employ the Anganwadi workers or the any Anganwadi worker or for the the petitioners in particular as BLOs in the different districts. Full stop. This court finds that the engagement of a particular employee on a particular job is the prerogative of the employer, and when there are specific instructions from the Ministry of Women and Child Development not to deploy Anganwadi workers for any other duty except for women and child related work and activities, comma, this court would not be, and it would not be upon this court to direct the respondents to engage the petitioners as BLO. Full stop. Accordingly, I do not find any merit in this petition, and it is accordingly dismissed. No order as to costs.
Obliged, madam. Madam, I am up to 6, but she is appealing for 7.
7. He doesn't have a correction for you. Thank you.
Obliged, madam.
Lordship, in this matter, we are preparing our affidavit in opposition, your lordship. So a 14 days time may be granted, your lordship. 14 days, your lordship.
You need 14 days.
Yes, your lordship.
Yes. Miss H. Terangpi, Learned Counsel, appearing for the respondent number
1 and 2, your lordship.
1 and 2. Raised for an accommodation of 14 days
14 days,
to
your lordship.
file the affidavit in opposition. Full stop. Shuddhodin glad you. List the matter again on 24th of June,
Yes, your lordship.
2026. Mr. P. Nayak appears for the
SCRD, respondent number 3.
SCRD, respondent number 3. You would not be filing an affidavit?
They should just suppose they should just.
Yes, lordship.
This case, 1 week time is required to file affidavit. 1 week time, madam.
Yes. Date may be fixed, my lord, my only prayer.
At the request of the Learned Counsel, appearing for the respondent number
345.
345, comma, list this matter again after, list this matter again on June first week due?
Yes.
Did we affect that? 5th of June, 2026.
Obliged.
Your lordship.
Yes.
If I'm assailing a transfer order, I'm
Instruction will file affidavit, my lord.
I have a, basically my contention is that I have a daughter which is 85% disabled. And I'm taking care, and I have come across another notification of the CRB itself that says this. No, let him file the affidavit. Till then, my lord.
Yes, sir. Could you say?
My lord. I have received instruction, my lord, I'll file affidavit, my lord, because on this ground, my lord, the petitioner was already accommodated on earlier occasion.
Take away the child's disability. Do not accommodate him for 1 day. Take away the disability of the child.
My lord.
Can you do that?
Cannot, my lord. But
What
again,
is
my
one
lord,
of
to what
opportunity to
extent-
opportunity?
My lord.
Person with disabilities action option.
The circular clearly says, my lord, that rotational transfer in such cases, relaxation can be given in, my lord, that is.
Not relaxation can be given. I will show you the right of the disabled child. You want to see that? It is there in law.
No.
There is a right of the disabled child to have the caregiver with him all the time.
All the time. My lord.
We have not opened the file, but we are just
My lord.
recollecting.
Yes.
Office memorandum.
There. Yes, my lord.
Show us one reason why he is the only man who can go and tackle the post of, what is his rank?
Head
Of the
constable.
head constable away from the child.
Whereas my lord is referring to a notification of 2024 February. Perhaps.
No, there were office memorandums from 2008, if I remember correctly.
2018 is also there, my lord.
When was the transfer order issued?
It was in December 25.
No.
Well,
Ah,
these are
December
December
25.
22 February or 22.
And more particularly, you have to show us from your, even if you can show us from your instruction.
My lord.
This rejected part, you've given the rejected, no, at page 25.
Yes, yes.
Rejected.
My lord.
That, do you have that office noting which says that
No, no.
even after considering that
Yes.
the wife,
But
that the
that is-
child needs,
that
the
is not
person with disabilities at section 30?
34, I think. 34. Benchmark 2034. Section 2 are as
Right to caregiver.
2016 minus.
90, I'm being given the 95 back again. 16 এখন আছে যোৱা তিনিবাৰ মান এতিয়ালৈকে মোক এখনে দি আছে
Amended.
এখনে থাকিলে নহব লিখক আজি কোন 2016 খন লাগে you have the 16 act
I don't have now. Right now, I don't have.
there is a particular provision in the 2000 in the latest act
My lord.
caregiver no movement
My lord.
there is an order by Justice Sham if I'm not wrong
My lord.
saying it is not the father crying not the employee
My lord.
who is it that child
Child.
how much time you want
My lord, the week's time, lord. I have already.
any interim
No, my lord. I want to press for interim.
an interim or an assurance
Interim will do, my lord, from rep.
interim because my lord see
Kind of.
then the council is permitted to renew prayer for interim.
During election time, it was not
But
given
now,
effect
now
to.
it has to be considered.
And I don't know whether at present moment, whether movement or release order has.
We will say that will not be required to join
No, no.
at the new place of posting.
No. Well, some in other matters, well, I am one of the courts have passed orders that no movement order shall be issued.
Yes. Mr. H. Gupta, Learned Counsel, Learned CGC appearing in the matter has submitted that instructions have been received and the respondents will be filing an affidavit in opposition, full stop. The Learned Counsel, Mr. D. Gogoi, appearing for the petitioners, petitioner has submitted that the daughter of the petitioner
My lord.
is suffering from cerebral palsy. Where did we find that letter, that
My lord, that is annexure 6, my lord, page 35.
35?
There's a certificate, my lord.
From the disability board?
Yes, my lord,
Oh, yes, joint.
disability board, my lord.
Is suffering from cerebral palsy with 85% disability. And is which disability is included in the RPWD Act 2016. Full stop. Allowing Mr. Gupta to file the affidavit in opposition by the respondent authorities, comma. List this matter again on. Tell us a date, Mr. Gupta, to your convenience.
After a week, my lord, any date. As per convenience of lordship, after a week, my lord.
Pick a date.
My lord.
আজি কি তাৰিখ ন?
আজি কিমান?
আজি হেৰি আকৌ, আজি 20। অহা সপ্তাহ ল'ব লাগিব আপুনি। মঙ্গলবাৰ মানে
My lord, 2nd of June, my lord.
2nd of June 2026. Full stop. The affidavit shall contain details of the process by which the order dated 10/2/2026 had been passed rejecting the request of the petitioner for retention. Full stop. The list again is aforesaid. In the meantime, the petitioner shall not be the no movement order regarding the petitioner shall be issued. Full stop. This interim order has been passed keeping in view the rights of the disabled child to have access to the caregiver under the RPWD Act
2016. Leave regulations.
This is not on the merit of the service or anything. It is only because the child has a right to the
My lord.
caregiver.
My lord. My lord.
2nd of June, please.
I'll let you.
35 perhaps my lord may not like to take up.
List before any other court without me.
Obligement.
We appeared in this matter before. 2026.
This person had approached court earlier and when lordship was decided. Obligement.
Lucky him or lucky you?
Both ways.
Obligations.
Yes, item 61. Penders.
Lordship, my lord, here, whatever the petitioner has been, was appointed as far back in 1995. As per annexure A, my lord. And now he was seeking in view of the 2019 circular of the government of Assam, Finance Department. He is seeking fixed pay. He's getting 9,000 rupees now. The circular is my lord, last page, last one can see. Annexure A, page 24.
24.
Yes.
It
says, my lord, the FRM came into effect from 1st of September 2005. And the employees who has been engaged or appointed should be prior to that. And this man is appointed as far way back in on 28/4/1995. Annexure A is clear. Now they have last time they brought some instructions saying that no, he's not entitled.
I think when the learned counsel appeared on the last occasion, he was required to have some instruction on this submission.
They have brought some instruction. Annexure D1, another type copy of the.
But in fact, I had the instructions, my lord. That proposal has been received in the finance department.
Okay.
Yes. Now they are working on it. My lord, whether at all, my lord, the petitioner will be entitled to the minimum scale of pay. Lordship, maybe please to dispose of this writ application. Maybe, relegating the petitioner, my lord, to the authorities and let the finance department take a call, my lord. Let the finance department as well as, my lord, this,
No, the main department will take a call
yes,
on the, by taking into consideration your views on the matter.
excellent.
You are not the person to regularize or to
No.
give the consultative
No,
pay or anything. You would only concur or you would
Yes,
disagree.
yes. So far as, my lord, the minimum pay scale is concerned,
Huh.
because he is claiming only the
You would
minimum
advise
pay
either to give the minimum pay scale or not to give the
or
pay
not.
scale.
Yes, that much.
Yes, sir, what is?
As per the circular is entitled, it's got their own circular. Because you will also only see, just.
No, when the matter has already been forwarded and is under this consideration that whether it can be paid, should we await the outcome or should we?
No, may just one line. Appointed for the master role worker, work hours, casual, and similarly placed employees who were engaged prior to FRBM period of 1st of September 2005. This clearly says we should get anyway.
We must have been engaged prior to.
First of the effective date of 1st of September 2005, on which date the FRBM came into effect. This is 1995 appointment.
How much time could it possibly take?
2 months minimum, my lord.
Huh?
2 months.
2 months.
I
Because,
don't
my
think
lord,
he's going to agree for 2 months. You can speed it up because it's a repetition.
no, my lord, difficulty is that, my lord, they
You
are,
received the proposal.
no, received the proposal, but finance department is going to take a call, my lord, in an aggregated manner, because lots of proposals are now coming from various departments. The difficulty is that, my lord, after issuance of this notification, it is, my lord, 3rd of October 2019, which is the last page of the writ petition. These proposals are again forthcoming. This was, my lord, floated, my lord, with a view, my lord, that it will be a one-time exercise. Because Upendas doesn't give a window, my lord, that you continue to give, my lord, minimum pay scale. So that will be a havoc in the, my lord, economic health of the state. So therefore, considering all the pros and cons, my lord, the finance department is going to take a call. It will involve some policy decision, my lord. So therefore, now since there is a formation of a new government, so therefore it will take some time, my lord. This is what my instructions state.
We will have it sometime in the sometime before the vacations. Maybe you
that
can
can
give
be
us a
done.
more
Yes, absolutely.
concrete date or a concrete time frame as to when the finance, how much proposals have been made, what is progressing.
Because my
Can it be
instruction,
done, sir, on that?
my instruction also says, my lord, that it is under active consideration. So they are doing it. It is not that they are not doing it, my lord. They are doing it. And the petitioner name has also been, my lord, proposed by the Women and Child Development Department. So they are doing it. It's not
Should
that
we
they are
wait
not.
for some time, sir?
Certainly.
Heard Mr. R.P. Sharma, learned senior counsel, assisted by so-and-so learned counsel appearing for the petitioner. Mr. Arbor Pujari, learned counsel appearing for the finance department, has placed before this court an instruction dated 15th of May 2026, according to which the proposal of the petitioner has been placed before the finance department for their comments on the matter, full stop. Now, go for the
It is with regard to giving concurrence, my lord.
before taking a final decision on the grant of minimum of the pay scale to the petitioner. full
My
stop.
lord.
Accordingly, Mr. Borpujari prays that the matter be listed after 3 weeks to enable him to have an updated status on the consideration of the proposal in respect of the petitioner. Full stop. List the matter again on
18th of June.
My lord, can it be in the last part of June, my lord? Preferably, my lord. But can it be on 23rd or 24th of June, subject to Lordship's convenience.
23rd of June.
23rd of June.
Huh? 22, 22nd of June.
Yes,
You'll have it on
yes,
22nd.
my lord, no difficulty.
More than
I'm so obliged. If Lordship may be pleased to keep my instruction as a part of the record. my lord.
The instruction placed before this court is kept as a part of record and marked annexure, and marked as X. We are still on the annexure part.
X or Y, but I'm so obliged. Yes.
Yes, this name we have heard. Hmm. Yes.
No, the gratuity part remains, my lord.
Uh-huh.
Gratuity part remains, my lord.
Ah.
They have made the calculation, my lord. They have annexed also
Ah.
at page 58.
Earlier occasion, he was claiming the pay revision, my lord. Now he said only the gratuity part left.
So there were two pairs. my lord. that part goes, my lord.
One at a time. One at a time. What do you say on the gratuity, sir, then?
Yes, gratuity he is
Entitled.
he has to get it, but he has to make application to the tandoor unit, my lord.
The position is as such, my lord. The petitioner, my lord, he had a stroke, my lord.
Ah.
Now he's
Get it done through your, we'll take note of the medical condition of the petitioner.
Yes, yes.
Allow the application for gratuity to be moved to a family member. Who will move it?
representative, my lord.
Or representative?
Yes, yes. But he has to make application, that is all.
Give, ultimately it will go to his account. Nowadays it cannot go to
Yes, yes.
someone's hands.
So he's accountant. He will give his all account and all
So we'll
particulars.
give, we'll say that he will make an application.
Ah.
And from the date of the application, within 3 months, they would decide on your entitlement, let you know what is your entitlement on the gratuity, on the with respect to the gratuity, and make the payment within a further period of 1 month. That is on a total of 4 months.
Yes, yes.
The gratuity would be cleared.
Yes, yes.
That can
yes,
be done.
Yes.
Hello, can it be sent by post, my lord, that application?
Whichever way.
Yes.
Or we can even allow you to have it deposited in their local office if they
Yes.
have one, from where they will take the pen to forward it because he is not keeping well.
Yes, yes, yes.
Is it not?
Yes.
Okay, take down. Heard Mr. P.K. Muni, learned counsel appearing for the petitioner. Also heard Mr. J. Roy, learned senior counsel assisted by appearing for the respondent, Cement Corporation of India, full stop. The matter had been heard on previous occasions and the learned counsel for the petitioner was allowed to have his instructions on the matter. Full stop. Today, the learned counsel has submitted that the petitioner, the gratuity of the petitioner remains the only issue to be adjudicated in the matter. Full stop. He submits that the gratuity of the petitioner is required to be paid at an early date by the respondent authorities. Since the petitioner is at present suffering from several ailments and is not in a position to maintain himself properly also. Full stop.
Paralyzed, my lord, left side.
He submits that the petitioner has suffered from paralysis and therefore an early disbursal from the respondent authorities would be necessary. Full stop. Mr. J. Roy, learned counsel appearing, learned senior counsel appearing for the Cement Corporation of India has submitted that the petitioner has to file an application claiming his gratuity benefits. And if such an application is made, he assures the court that the respondents would look into the same promptly and have the same disbursed to him at the earliest possible time. Full stop. Accordingly, this writ petition is closed, allowing the petitioner to file a representation, comma, if required through a representative, comma, since he has been said to be suffering from paralysis, comma, to claim his gratuity benefits. Full stop. The application may be submitted to the office, may be submitted through The office, you have any office here
Yes.
where it can be submitted?
Yes. Tandoor unit, my lord.
The Tandoor unit will be at Andhra Pradesh. Somewhere where he can have his
Number
application.
two, number two.
Me-
Three is the general manager, Bukajan.
We'll have it at 3. The application may be routed through the respondent number 3, that is the general manager, Cement Corporation of India Limited, Bukajan unit, for onward transmission
Yes.
to the office of the deputy general manager within bracket PNA Cement Corporation of India Limited, Tandoor Cement Factory, Rangareddy at Andhra Pradesh. Full stop. Upon receipt of the application by the respondent number 3, the said respondent shall forward it to the office of the respondent number 4, who shall thereafter take necessary steps for disbursal of the gratuity amount to the petitioner at an early date, full stop. The respondent number 4 shall intimate the petitioner regarding his entitlement to the gratuity amount within a period of 2 months from the date of receipt of the application by the respondent number 3, and the respondent number 4 shall also attempt to have the disposal of the gratuity amount made to the petitioner within a further period of 1 month thereafter. Yes?
Only thing was, let it be 3 months because it will go Tandoor unit and.
No, we are saying that 2 months you tell him this is the
Yes.
amount,
Yes,
and 1 month thereafter you make the payment.
yes, yes.
So total of 3 months we have given you.
Yes, yes,
Will suffice?
yes.
The petition
Only,
disposed of.
recorded, my lord, gratuity under the payment of gratuity.
Gratuity under the payment of gratuity accrued. Thank you. Sorry.
My lordship, in this case, the order dated 2004-2026, matter was fixed for instruction.
This is secondary education.
Secondary education.
What is your prayer?
There is petitioner is appointed as a lawyer division assistant.
LDA, Lahoriga Junior
Junior
College.
College. The service was not provincialized.
So, why was it not provincialized? What Mr. Islam Council appearing for the petitioner? On the earlier occasion, on an earlier occasion, that is on 24/2026, Mr. P.P. Dutta, Learned Counsel, appearing for the Secondary Education Department, was required to invariably complete his instructions with regard to the claim made by the petitioner. And it was provided that no further adjournment shall be granted for completion of instructions by the Learned Counsel for the respondents. Today, Ms. H. Therapy appears and submits. Yes.
Lordship, here the instruction says that the service of the petitioner was not provincialized due to non-fulfillment of eligibility criteria laid down.
Which one? There are several eligibility criteria.
Yes, Your Lordship.
Name one of them.
Section 4. Section 4.
Then you have to tell us which of the criteria. Was he not tall enough?
Item 63.
Was he not tall enough? He was not healthy enough. What? What is that criteria?
Lordship, here it says that the service of the petitioner was less than 6 years, Your Lordship. So he should.
Yes, which
go to
criteria
6
did
years.
not fulfill? Tell us. According to you.
My lordship, petitioner was appointed as the LDA in the third post. After that, the petitioner post was upgraded to the second post, page number 20.
Then?
Page number 20, petitioner name was forwarded, the Inspector of School Murigao to the Director, Secondary Education Ashram Kahilipara.
Okay, today Miss H. Learner Council appears for the respondents and submits that an instruction has been received that the petitioner did not fulfill the eligibility criteria to be considered for provincialization. So, the same does not appear to be complete instruction by the respondent authorities, since the criteria which has not been fulfilled by the petitioner has not been spelled out. List this matter again on the 23rd of June, by which date the respondent shall ensure the filing of the affidavit in opposition, failing which the concerned authority file the affidavit shall remain present before this court. Who should come, the IS or the director? From whom has the instruction come?
From the director.
Failing which the director of secondary education may be required to be present before this court on the next date of listing.
Otherwise,
Yes, when there are specific orders, why is the instruction not complete? Why do you force us to give this
So
kind
the
of
same
orders?
instructions I have received
Huh?
today.
Maybe they will explain on the next date. Hopefully. Yes, this is item 36. Tell us. Orders, Niki.
As per, as per order dated, Lordship Court Order 4/2/2026, we were supposed to take steps on respondent number 21. Lordship, we have taken today, Lordship.
You have taken your steps to the learner council for the petitioner submits that steps on the respondent number 21 has been taken today.
Yes, Lord.
Accordingly, list the matter after 4 weeks with service report.
Obliged.
This is 2017 matter. You are taking steps today. Why? You forgot about the case.
Lordship, I apologize, Lordship.
Huh?
I was.
Item 38 years, sir.
Lordship,
Hmm.
Lordship, petitioner not in communication, Lordship. Maybe matter, maybe order may be compared, maybe Lordship matter may be closed.
The learner council for the petitioner has submitted that there is a probability that the orders passed by this court has been complied with.
No.
Accordingly, this contempt case is closed.
Lordship.
Full stop. The petitioner will have the liberty to agitate any fresh grievance
Lord.
with regard to any orders passed by the respondent authorities.
Clear. May it please be your Lordship. Lordship, as per the order dated 9/8/2023, we have approached the CDPO, that is respondent number 4 for service in respect to respondent number 5. And he, at that order, court has directed to pay the expense amount for the steps for respondent. He asked 5,000 rupees for the expenses, and we have requested him to consider the amount and ask him to acknowledgement of receipt of the amount, but he refused to pay
Yes.
the acknowledgement receipt.
They have 5,000 for service of notice.
I don't.
Huh? Half the salary of most people.
Lordship, my financial position is
9,600
very.
is their payment.
Notice has
Anganwadi worker.
Yes.
Anganwadi worker.
5 is private respondent, Lords. Yes,
To be
Lordship.
served through the CDPO. He goes to the CDPO. CDPO says 5,000. The salary is 9,600. Have your instructions? Or should we
Lordship,
give
they
a
have
copy of
taken-
the writ petition to you so that you can forward it to the CDPO who will have it served and give you back?
Yes,
If they approach, this will go on.
Lordship, as per the order dated 8/1/2021,
Huh?
they have received an instruction and affidavit yet to file.
That is okay. You have got it listed after
After,
nearly 1 year.
yes,
Let us not go by that.
because case,
Where do you say that they have asked 5,000?
and refused to pay the, refused to give the acknowledgement receipt also.
Where is that refusal?
The refusal is not here.
Something else in your affidavit, something else in your submissions. The learned counsel for the petitioner has submitted that.
This is
See,
submit-
affidavit is for dusty service. They
It's
refuse to
to
take
the
dusty also.
Dusty service.
We have take step dusty 2 times. First time they refuse. After that, respondent file. After that, we have take steps by dusty. We
Just a minute.
obtain independent witness.
Just a minute. The learned counsel for the petitioner has submitted that the respondent number 5 has refused service, and to that effect, an affidavit has also been filed on
Respondent,
15/5/2023, huh?
Yes.
respondent number 5 is working or not, it is also not known, that's it.
One,
Instruction.
one report from you, he'll give you a
Yes,
copy.
Yes, yes.
You send the copy. They
Yes.
say not working, you tell us.
Yes, yes.
The learned counsel for the petitioner shall submit an extra copy of the writ petition upon Miss Burwa. Learned counsel appearing for the respondent number
1, 2, 3, 4.
1, 2, 3, 4. Full stop. Miss Burwa is requested by the court to forward a copy of the same to the respondent number. What is the CDPO name? Respondent number?
4.
5.
To the respondent
CDPO
number
4.
4.
CDPO 4.
With a further request to have the same served upon respondent number 5 if she is working under his jurisdiction. Full stop. A report from the respondent number 4 regarding the service of notice on the respondent number 5 will be placed before this court on the next date of listing. List the matter again on June or end of July after vacation detail immediately. 16th of July, 17th of July, 17th of July, 2026.
But there is an interim order.
Saying what?
Status quo order.
Interim status quo directed shall be continued to be maintained.
Highly obliged.
Wait to your lordship. Matter your lordship, Mr. Dean was supposed to place the instructions as
But you were saying that there are similar matters listed.
it's listed all together, your lordship.
All are listed together.
Not together, some are still left.
May I please, in respect of item number 43,
Huh?
item number 43. or-
Where is that order of which
It's order, the order.
violation is?
1st of February 2023.
Huh?
1st of February 2023, your lordship.
I remember the name.
There's a common judgment, your
I
lordship.
remember the name. One common judgment for all.
Yes, your lordship. One.
Where is the judgment? Where is that order? This is 7360, page 9.
Yes, your lordship, page 9. This is a common. This is a single.
Oh, no. The name might be similar, the subject matter is totally different.
Different, your lordship.
Is this
Item number 43, the order has been complied with, my lord.
order complied with?
Yes, yeah.
Very good. In respect of the contempt case number?
43.
Huh?
43, Babul Das.
Item number 43, who appears?
Yeah.
You are appearing in which item, madam?
41, 42, 44, 45, 46.
I'm for 40.
Go on for 43. That is the only order which is complied with. Yes, what is that order? Dioksun ekhon?
They appear for
43 also, yeah.
43 also, your lordship.
You appear.
Is the number.
Your matter was placed before the SLC
Yes.
and was rejected. Closed. 43 we can close. Directions were to consider for compassionate appointment. Rejected. Press cause of action.
Lordship, could that order be placed on record?
Now we'll keep it on record. We'll keep a copy of this on record. Or you want this on an affidavit?
Or perhaps in an affidavit?
In 43, I pay for the respondent number 1, who is already retired from service, Your Lordship.
Doesn't matter. Your retiring will not matter. Heard Miss so-and-so and a council appearing for the petitioners in item number 41 to 48.
Not
Or which one? 41 to?
40 is yours. 41, 42, 43, 44, 45, and 46.
Mr.
I am for 40, A Boro.
A. Burwa for 40.
A Boro.
A. Boro for item number 40. And madam, you are appearing for?
Oh, no, she's
Oh, she is assisting you.
not
Okay.
testing.
Mr. Adas appears for the
Except item 46 in all the matters.
respondent number 1 in all.
Some sole responding in some matters also, respondent number 1.
For the respondent number 1 / sole respondent in all items
Except
barring
46.
contempt case number.
575/23 of 2023.
Yes, madam, you are appearing for?
41, 43, and 44.
Madam appears in item number 41,
You are
43 and 40.
44.
You are appearing, sir? In item number 43. And this 43 you are saying is complied to. Full stop. Item number 43 in contempt case number so and so, item 43 number to দিব. In contempt case number so and so, the learned counsel has submitted, the learned counsel for the respondents has submitted that the matter of the petitioner had been placed before the state level committee meeting on 24/12/2025 for consideration, and the state level committee decided to reject the application of the petitioner for compassionate appointment. Full stop. The minutes of the aforesaid meeting are have been placed before this court. Full stop. In such view of the matter, this court is of the considered opinion that the orders, the order dated 22/2/2023 passed in. What is your WPC number? Four double three.
438.
Huh?
438.
No, that is the contempt case number, madam.
Oh, sorry.
What is your WPC number? In WPC number, contempt case of the silo, huh? In WPC number so and so has been
68.
complied with.
68.
Stop.
68.
Accordingly, the aforesaid contempt case is closed, granting leaving petitioner at liberty to assail the rejection. And to approach the court, if any grievance further remains, stop, by filing appropriate application. Okay, on the rest of for the rest of the matters, in the other contempt cases, there is no compliance report placed before this court today. Stop. These matters again on 12th of June 2026, on which dates the respondent shall ensure the production of compliance reports, failing which their personal appearance may be called for.
DNAP was supposed to proceedings in all the contempt matters, Your Lordship. As
He
per
will do it the
direction of
next
this-
time because he will do it on the next day, don't worry.
Because
He will do it on the next.
oblige, Your Lordship.
Kita assumption. This 45 what is it?
Yes.
Lordship, perhaps this matter has to be listed before another bench.
Before another bench.
Yes, Lordship has appeared in
Oh.
this matter.
That long series
Yes.
up to 49. List before any other bench without me.
Challenge.
$50 পিছত কিমান হ'ব? Yes.
Well, please, your lordships.
Lordship, here the writ appeal was listed for delay condonation on 15th of May. And the next date is on 22nd. Lordship may take it up in the first week, Lordship. Of
List
July.
this matter again on 10th of June,
No, Lordship.
July.
July, because
On 17th of July. Since a submission has been made that a writ appeal has been filed and the same is under consideration.
Deeply obliged.
Yes.
Made please, your lordship, service for respondent number 5 hasn't completed. Matter may be come up in admission column.
I filed my response, lordship, so far as
The response on behalf of respondent number 2, 3 and 4 has already been filed. Mr. R.K.D. Chaudhary, Learned Senior Counsel appears and is appearing for the said respondents. Full stop. The Learned Counsel for the petition has submitted that the service of notice on the respondent number 5 is also complete. Full stop. Accordingly, she prays for listing of the matter in the admission column. List this matter again for admission. Any urgency in the matter?
Not such.
In the month of July 2026. Yes.
Yes, ma'am. Order dated 28 to 2024, my lord.
Have you taken steps?
Yes, my lord.
18/5/2002, 18 of May says no steps received.
As per order dated 11 to 2026, my lord.
Huh?
As per order dated 11 to 26.
Notice says steps not received.
Yes. Then my
No steps received. You have not taken steps.
steps already taken, my
The
lord.
office note reflects that the steps have not been received till 18/5/2026. Learned Counsel for the petitioner submits that steps have been taken. Learned Counsel shall
I may be
reconcile with the
allowed to-
registry.
I may be allowed to take further steps, my lord, if not.
Learned Counsel for the petitioner is allowed to take fresh steps on the respondent number
Yes.
4, 5 and 6.
Yes.
Next.
Obliged.
List after 4 weeks of taking of the steps.
2 weeks, my lord.
After 4 weeks after you take steps,
Tomorrow I'll take.
tomorrow you'll take steps, but how will it reach? In 2 weeks. We'll have a service report in 2 weeks. General clauses like 4 weeks.
2024, madam.
Okay, dear. 2 weeks. After 2 weeks
Obliged.
of the steps being taken.
Yes, sir, I appeal for respondent 1, my lord. I need some time to file affidavit.
Time to file affidavit. List again on, when do you want it?
After 2 weeks, my lord.
After 2, so 2 weeks of data. Allowing the respondents to file their response to the contempt case. Mr. So-and-so appears for the petition and delivery. 17 June.
17. My lord, I have to take a step in the contempt 193 upon respondent number 5.
Petitioner is allowed to take steps, fresh steps on respondent number 1.
Respondent number 5.
On respondent number 5.
Deeply obliged.
Yes.
5.
Hello. There is an amendment application, my lord.
Little shortage of time, sir. I have a
Yes.
pre-engagement at 4:45. We'll have it listed on the next week. to your convenience? Wednesday?
Yes.
List again on Wednesday due to paucity of time today. Huh? Wednesday is a holiday. Have it on Friday? Oh, on 29th. Sir.
Can it be next Monday, Madam? 29, I've got other cases fixed.
Oh, you choose it?
Now, 1st of June?
1st of June. 1st of June.
How does
Yes.
May reason also. Office note dated 12/5 shows that affidavit in industry has not been filed, but on the 12/5/26, I have filed affidavit for.
Appearing for the private respondent, Lordship.
Sorry?
For the private respondent, I am appearing, Lordship. Respondent number
Mr. Swain Council appears for the respondent number 5.
7.
Respondent number 7, full stop. The Learned Counsel for the petitioner has submitted that he has also filed an affidavit showing service of dusty notice upon the respondent number 7. Full stop. Since the respondent number 7 has been represented, list this matter again. How much time you need?
Lordship, on short date, Monday, Lordship.
Tuesday,
Because-
it's Tuesday.
Tuesday?
Tuesday.
On Tuesday. 26th
Not on.
for consideration.
26 of the.
It's
26 of.
Yes.
26.
Lord, pension is to be paid by the department. They have not processed yet.
I'm appearing for 1, 2, and 4, my lord, from the end of the end of the respondent that has been complied. It is sent to the AG office.
Learned Counsel appearing for the respondent number 1, 2, and 4 submits that the submits what? That the case of
A
the
copy
petitioner has been forwarded
Forwarded
to
to AG office.
the AG office
Pensionary benefit.
for full compliance of the orders of this court. Full stop. You are to initiate from director to senior accounts
There is
officer.
the letter of director, my lord, 10 December
Full stop.
25.
Awaiting further process at the office of the AG. List this matter again on July DDO. First, ekdom opening on DDO. 15th of July, 2026.
Can it be on 17?
17th of
17th,
July,
right.
2026.
Okay, no problem.
The copy of the instructions received by, produced by the respondent, Learned
One.
Counsel for the respondent is kept on record as X.
One copy may be provided to us, my lord, so. Because
The
it is commonly
Learned
given.
Counsel for the respondent shall also provide a copy of the
Helpful.
instructions to the,
Alright.
of the communications to
Communication.
Mr. B. Castle and a counsel paying for the petitioner. Yes.
Alright.
You're right, the order has been complied with, my lord. I'm going
Yes,
to.
Lordship,
Order has
complied.
been complied, Your Lordship.
The Learned Counsel appearing for the parties are at consensus that the orders passed by this court has been complied with and nothing further remains to be executed. Accordingly, the contempt case is closed on compliance. Yes.
Obliged, Your Lordship.
Out regular. Data. Duta eta tinta ko. You want the orders?
T9.
Data thank you. Anything urgent, sir, on this?
My lord, just the interim order is to continue, and they have to file objection, they have not filed yet.
No, but they filed, my lord, IA, my lord, but notice has not been issued.
Which one?
Lord, that item 59.
Item 59. Issue notice.
Notice not been issued. Lord.
Issue notice.
নাই কৰা কেতিয়া কৰিম
Last date.
Okay. Mr. Hendrik Learned Counsel appearing for the respondents.
Revenue Department, but one-
application. You need what, extra copies now?
Lordship.
Has paid for the supply of extra copies from the counsel for the petitioner, full stop. Learned counsel for the petitioner shall supply extra copies of the IA of Mr. J. Hendrick, learned counsel appearing for the respondents within a period of 3 weeks or 3 days from today. List the matter again on when do you want it?
Lordship, next month, any day. After my lord,
22nd of June.
Lordship.
Interim order will continue on.
The interim order passed earlier continues. Any urgency? Which one?
Item number supply 65, my lord. On the your lordship had kept it for further and today, my lordship fixed it that.
Anybody else appearing on the other side?
Yes, your lordship. Is there, my lord.
We'll have it tomorrow.
Tomorrow, my lord.
Tomorrow morning.
Morning.
Huh? Tomorrow to Kaile can do.
65, supply 65.
65.
Supply
Okay.
65.
65 list tomorrow. Hobo apni 65 to dibo list tomorrow 15 and a matter order to RP Somasar to. Ane? 65 to dibo list tomorrow bad list. Or day after tomorrow. Day after
Up to your lordship.
Day after tomorrow. 65 day after tomorrow. Okay. Remind me in the morning so we can take it up early.
My lord, I'll do that. I'll make a mention. Deep level.
65 P.
65. Purohi. Yes.
Done. 65 done. 66 key. How are you?
My lord,
Next.
66 is a matter regarding the apportionment of the family pension between two wives. Matter is almost decided. Only one part of it remain, my lord.
Wednesday?
It will take, my lord.
Wednesday next?
My lord, on last occasion also.
Oh, Wednesday is closed. When?
My lord.
On 29th.
My lord, I have some difficulties, my lord. Maybe on 26th, my lord.
26th. Hobo? At the request of the counsel for the petition. Thank you.
All right.
Yes, I don't think that. Please.